Hey everybody, welcome back. This one is naughtier than a squirrel's breakfast. Now finally I've got my camera sorted out and thankfully my microphone is now completely free of tea. The sheer overwhelming volume of tea that landed in this microphone yesterday or the day before was unbelievable. I could have drank from the microphone. In any event, I hope it sounds a lot better than the last few videos. Sorry about that one. Anyway, this one is absolutely nuts. So it's a restraining order hearing. This guy's getting a restraining order against his ex-girlfriend. There's a whole load of craziness going on here. But the thing is, it was a massive roller coaster for me, not going to lie. I was completely believing her at the start of this. Like, I was thinking this guy's just a bit mental, to be honest, and he has all these conspiracy theories about what she's done. She would have won this case if she kept her mouth shut a little bit. But as her story began to unravel, things started to kind of now add up in the way that he thought things were. I think that sentence works.
All right. We're taking up case 2579, and you'll both notice that I'm looking from screen to screen to screen here. I've got a couple of screens, all of our court files electronic. So I'm listening to you, but I'm also looking at, there's a lot of exhibits that have been filed, and I'm looking at the things that were filed. So just so you know what I'm doing here. And then we're here on an order has been issued on behalf of Mr.
You say it Valva.
Valva. Thank you.
Yes, ma'am.
Let me get that right. Thank you. Mr. Valva, against Ms. Gooding. There was a temporary order. Today is the day we determined should this order go beyond today or not. So, Mr. Valva, let me put you under oath. Raise your right hand. It's all right. You swear to tell the truth, the whole truth, and nothing but the truth?
I do.
All right. And Ms. Gooding, raise your right hand with me. Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
All right. So what happens here today is I'll hear from Mr. Valva if there's anything more other than what he's filed, which is you filed a lot of information. You don't have to say anything more, but if there's something you wanted to highlight, that's fine. And Ms. Gooding, then I'm going to turn to you and ask you why I shouldn't issue this order. But of course, my first question, Ms. Gooding, is do you object to this order being issued?
I do, yes.
Okay, we have a hearing. So I'm going to turn to Mr. Valva and hear from him why I should do this. And I'll turn back to you and to determine why you think I shouldn't. And we're working under the law of RCW. Let me get that out. Let's go back. 7.105, 100, the anti-harassment order or protection order statute. So I have to find certain things there.
Mm-hmm.
So Mr. Valva, you said a lot of things here. Anything else or anything more, something you want to weigh in on?
Yeah, well, I've got the paperwork. I understand relationships and I understand that they go bad. But what was done, there's nothing that can explain.
Which one of these things that you're most aggrieved by? Is it the statement on Facebook?
The fact that, yeah, the 8 months that she used my picture and my name and my account and was in there making posts for 8 months, acting like me, writing posts. I got everything printed out.
Well, you put it all in the court file. So the 8 months, but what about those statements that aggrieved you the most?
Well, she said I was Thurston County's biggest sex offender, that I was a rapist and pedophile. I am not on any register. I have no violence on my record. I have no domestic violences on my record. I have nothing like that. And I have a 16-year-old daughter. And how am I supposed to? I lost my job because of this. For 2 years, I had a great job.
When did? Yeah.
And I couldn't figure out why I got fired because Monday we had talked and I had everything set up.
Well, here, let me back you up. We'll get to that. I'm trying to keep it a little organized. I know.
I get worked up and I'm really sorry about that.
I understand. Okay. So those 8 months, what time frame was that?
That was from May, beginning of May to the end of
May of 2024?
Yes, I'm sorry, May of 2024. It started in May of 2024 and it ended, I believe, just a couple of weeks prior to her being served, or a week to being being served.
Came to the court in March, so sometime in March it ended.
Yes,
Okay, before she was, as you understand, served notice of this hearing.
correct.
All right, and then you say you lost your job in that same time frame.
I lost my job in September.
All right.
And I had no recollection of this whole, that I just can't believe it. For 8 months, I didn't know anything about this. And to see how long and how many posts that she made, I'm just like, are you?
So what did you do for a job, and did you ever find out
I
why
was
you
a
lost your
commercial
job?
framer for Bailey, BGC, Bailey General Contracting.
All right, and what did they say about why you lost your job?
They said because it was slow. I had went in a week ago and talked to the secretary and asked if there was a specific reason why I was let go. And they had stated that they had information on a Facebook profile page of mine about me being a sex offender. And my boss was just like, look, if it is true or it's not true, I still can't have those kind of things being said because
So how did, so you got this from a secretary? And
well,
was
yeah,
the
my boss,
secretary
and my
part of-
boss, yeah.
Did you talk to your boss?
I didn't physically talk to him, no.
All right, so you heard this through another person, who's a
Yes, yes,
secretary to
through
your
another person,
boss.
yes, yeah.
And the secretary doesn't make the firing and hiring decisions?
No, she
The
does not.
boss does, okay, but you heard that that's what the secretary thought, one of
Yeah,
the reasons.
yes.
All right. And then you haven't been hired back?
No,
All right, and are you working anywhere else?
no, I was on unemployment. And then when this happened, since unemployment, I've been like depressed because I've been dealing with our breakup and moving. And then this happened and I've been a mess. I've tried to work, I've gone to work and I find myself getting depressed after a couple of days and then just refuse to go back because I'm just not,
So you're
it's
getting
sad. and
hired elsewhere, but you're ending the job yourself.
Yes,
Okay,
yeah.
all right, and so, you speak about, all right, so that, job, those are the big things. And things kind of stopped, you said, before you filed this, for this order. Do you have any concept of why?
Because when I found out about the profile page, I started digging into my phone more and realized that she was synced into my phone. And I have pictures of that, of her synced into my phone with a certain password that she has that I didn't have at that time. And it shows her name and her picture and my name and my picture are synced. And when she got served, my credit card information came off a spyware that she had used because I had my credit card information in my phone.
So again, back you up to
I'm sorry.
focus in here. Do you have any idea of why these things may have stopped before you even came?
Oh,
forward?
because I think she knew that I was figuring it out, that she was into my phone.
Okay, and how would you think that she would know that?
Because I would turn off certain things on my phone. And the next morning I'd wake up and they'd be back on again.
All right, so, and how do you attribute this to Ms. Gooding?
Well, I have her name into my phone, synced into my phone. And when I removed my email address that I thought that she was synced to. And when I go to recover that email address, because I have 2,000 work photos on there that were deleted by her. When I tried to recover that email, it asked me to send her email. It'll send her email a verification or a verification number. Why do I have to send her a verification number to
Is
get into
this
this?
email that you attribute to Ms. Gooding, is this the email that you may have used through your relationship?
Yes,
Okay.
yes, ma'am.
And how long was this relationship?
We did it for 3 years, from 2021 to 2020, about the beginning of 2024, because we were separated for a year, but we were still in contact. Because I have a dog and I would go down there and take care of him, walk him and stuff like that. And so that's why we kept in contact. And then when she did the restraining order, she took my dog and I'm just like, so that's the other thing.
Okay, I did notice that in, well, no, restraining order in what county? I don't see you as.
She
responded.
said it was out of this one, or the paperwork was done out of this one. If it wasn't, it was Pierce County, because I lived in Lakewood at the time when I was served.
Okay.
So I was certain, and then I was also, because of the issues that were going on, was also had to move out of the house I was just moved into a week prior. So now I'm back down here in Olympia, ma'am.
Okay.
I was there.
And
I
where
was
do
there.
you think Ms. Gooding is?
What?
Where do you think Ms. Gooding is residing?
At her residence, 411 Thomas Street.
Where's that city?
Oh, it's in Olympia. It's in Olympia.
Okay,
Yes, sorry
all
about that.
right. All right, so things seem to have ended right before you filed, and you filed anything since you filed for this order?
Yes, hold on, I have a, let's see here.
Anything you didn't file with the court? So I need you to testify. If you need to pause and review things, but you're the one who should be testifying, not
Right, no, I know,
someone talking to you.
There, just my pictures and stuff had been getting deleted and, yeah, everything of mine has been deleted off my phone, since
Everything of
the
yours, what
serving.
does that mean?
Since the time of her being served, my pictures, my personal pictures and my work photos, everything that meant something to me, my pictures of my dog were all deleted. The information, like I had a bill of sale wrote out for my car from my aunt, that was deleted. The information that I had that is in front of you about my dog, the citation, the vet bill, and the bill of sale was all deleted off of my phone. I had to recover all of it back.
How did you recover it?
Oh, I had to go in, it's unbelievable, Your Honor. I had to go into a few different photo recovery sites and pull out of the trash. Luckily, I had it down, don't delete anything after 36 months. And so I was able to get some of those
Off the cloud?
pictures back. Yeah. But I didn't get my work pictures. I'm still 2,000 pictures short. My work stuff, everything, all my other stuff is gone. So I'm
Okay.
really upset about that too. It's just, but
So let's see if I have other questions here. Give me a moment.
yeah.
Yeah, something, but
Well, I was just, and my daughter's sake, the other reason why is my daughter, we would get into little arguments, during the 3 years, and she would
you
just.
would get into
oh,
arguments, you and
Sorry,
who?
me and Meg Gooding would get into arguments, and in the middle of those arguments, she would, bring my daughter's name up for no reason, and say,
So how does this have to do with an order against Ms. Gooding? What you're saying right now is arguments during the relationship. Is there something?
well, I just thought that the protection order was for my daughter as well, and I just wanted to state that she doesn't feel safe right now with everything that's being said and done. And I have printouts, and you have it all. I have text messages and everything that says that when she filed, she made sure to do it on my daughter's birthday or the day she filed on
We're
the 5th.
talking about Caitlin?
Yes, Caitlin.
Okay.
Caitlin's birthday was on the 6th. Meg Gooding sent me text messages stating that she was going to make sure that I went to jail on my daughter's birthday so she could witness that. And then I got paperwork served to me on the 5th, and then the 6th they came, but because of no evidence,
What month? are we talking?
February.
February of this year?
Yep, February of 5th.
Okay.
Oh, sorry, her birthday is on March 6th. I'm sorry. So it was 3/5/2025
Okay.
that I got served
With what?
with a restraining order for domestic violence and battery and sexual assault. And she demanded that I give back my dog to her.
Is that in this county?
Well,
Do you-
yes.
Do you have a hearing coming up? What's happened with that?
It got dropped. No, her restraining order was dropped. So we went to court after they took everything, and we went to court, and the judge dropped the case. There was just lack of evidence.
Okay, I see that on April 4th, there was an order filed in the Thurston County Superior Court. And then there was an order denying that petition all on the same day. There wasn't anything issued. Let me kind of look and see what else I can know.
Okay.
So that was case 25-2-302-7134. And then there was also 25-2-301-8734. And that is looking into the JABS docket. Petitioner was Ms. Gooding against you, and those dockets were collapsed together. So there's a petition filed March 5th on that one. There's service, sheriff apparently served sometime around March 5th or 6th. And then the hearing was March 18th, and the Superior Court judge denied the request of Ms. Gooding for an order. So those things, there aren't any further hearings that I can divine. All right. And so you heard from, how did you know this from Ms. Gooding that this was her plan?
She stated in text messages that she was going to make a profile page of mine, making sure that everybody knew what kind of person that I supposedly was, and she didn't care about the consequences. She didn't care about anything as long as it ruined me. She stated that she was going to do this. She was going to make sure that I went to jail on my daughter's birthday so she could watch that. I didn't know it was a restraining order until I was served, because I was sick during all of this. And then, yeah, and then they came, and she knew, Meg Gooding knew with the laws, because I had my dog. What she did was she registered my dog behind my back a
So
week.
Let me step you back to what you were saying. So around March of 2025, around your daughter's birthday, is when you got a text, or sometime before that, from a text message that you have used with Ms. Gooding?
Yes, so,
Okay.
okay.
And she said in that text that she was going to ruin you. What did
yes,
she say exactly? You are not here. The folks in the back
Yeah,
have
no,
to sit quiet and
yes,
not raise their hands.
she says,
If you need a break to look at things, I'll give you that.
no, okay.
But I'm not gonna have people in the back throwing papers around.
Yeah,
raising
no,
hands.
I
This is
understand.
your suit.
So,
So did you file this with the court?
yes,
Okay.
all
so
of that
it's
has
one
been
these
filed.
Many images.
Yeah,
And it was a screenshot of
Yep, it was-
that text.
it was a screenshot of the text, yes,
And
ma'am.
that came in, all right, so why don't you go through that? I can't divine which text. it
Yeah,
is,
I
all
am
they
sorry
give me
about
is
not
image.
ordering these, and
Yeah.
that was
So
it's
do
my
you have a
first-
copy of it there that you're
Yes.
looking at?
right here.
All right, why don't you hand it up? And then I can see what you're talking about.
I might need a couple minutes to pull up these other pieces.
Well, let me just see this and then we'll talk about this.
ma'am.
Okay. All right, so if you can help me understand who's writing what. So you got another one for me to look at?
This is, so I have.
Here, what I'm gonna do is just make copies. Can you make copies of these? And then have a seat, just wait. Let me get copies and then I can sensibly talk to you while I'm looking at what you're giving me.
And then this is, do you want also printouts of like the profile page?
I just want to look at this right now, what we're talking about. Try and stay focused. Can you give me all that? Can you give me the packet as well? Let's see, I'm gonna give you back the one that has, all right, here you go. I'm gonna give you these back, highlighted and underlined, and then we'll talk about what all this is supposed to mean. All right, so these look like screenshots from a cell phone. Is this your cell phone screenshots
Yes,
from?
yes, ma'am.
And when did these messages come in?
These came in, I have it all in my, these messages came in, let's see here. I have it all dated, I just, these messages came in, in the beginning of March, end of February.
Okay, so before you filed.
Yeah, but wait,
And
yes, this is
then
before I filed.
I've got 2 pages here of screenshots. One says, I'll ruin your life and everyone you love. What's that one? Who's writing that?
That's Meg Gooding writing that.
Right, and you think that that's Meg Gooding because,
I have pictures of her and 2 other names on her profile page with her real name matched to these 3 names that you see right there.
okay, so this is a.
This is
So
on
this
Messenger.
comes into your phone. It
Yes.
says Meg Gooding.
Yep.
All right, and I'll send your mom and Sally all your internet history. So then I see an emoji of a flipping, giving someone the
Mhm.
bird or flipping someone off with their middle finger. Is
Yes,
that
ma'am.
you or?
No,
who's
that's
that?
her.
Okay, and then is all of this?
That's all her, ma'am.
Okay, so no response from you in
Nope.
this one.
No,
All right, so this is what you're saying. I'll ruin your life. I'll send your mom and Sally. Who's Sally?
I'm my aunt. She's like my mom.
Okay. And then it says, see you later today. enjoy what little reputation you have. And then I'll have a profile for you made on every hookup site outlining. All right, and then the next page starts with enjoy that fucker. Who's that from?
That was from Meg Gooding, ma'am.
And in the same way, is this part of a whole stream?
Yeah, that's all Meg,
Which
yes.
started first? I'll ruin your life, or which started first?
I think it was,
Yours, and tell me.
yeah, it was, I'll ruin your
That
life.
started with that.
And then
alright.
the end, and then that would be the end of
So
it.
are there any responses from you in these?
Not for these, no.
Not what I'm looking at.
Nope,
All right.
not at
so
all. I didn't
what does
respond to any of
See you
those.
later today mean?
When, because that was the day that she was filing, or that was the day that I was getting, the restraining order, I guess, put against me. I was sick and my phone was off. I didn't get any of these messages, so when I turned on my phone after I got served, I seen all these messages and was like, what the hell? And then,
So these came in uninvited from you. You hadn't texted or anything? Or-
no, these messages, no.
Okay. And before this,
Mhm.
how recently had you had any conversation?
Oh,
by
we had been
text with Ms.
talking,
Gooding?
we had been seeing each other clearly till all the way up until like a week before I was served, so a week before March
Right.
5th. Yeah, we were
So
constantly talking and hanging out, like we were friends.
So where does this come from? What happened?
This is just this is the stuff that she sends to me, and when we get into what it is, ma'am, is that
You got into some sort of
I got custody
disagreement.
of my daughter.
Mhm.
If I can't give Meg my 100% attention, which I have text messages of this too, if I can't give her 100% of my attention, that she gets very upset. And these are the things that I've been trying to help her out with, because she is on medical leave. I don't want to
So
talk
you
about that. I don't
think
want to
this
talk about that.
so this came after some sort of disagreement you
Yes, yes,
had? How
yes, yes.
soon after?
A couple days, maybe. She kept asking me to bring my dog back, and I'm like, I'm sick, and he's mine. I'm
Okay.
like, and so the
So
only
this
way.
disagreement about the dog is what's going on.
Yes, yeah, this whole,
also.
yeah, and the
All
reason
right.
why we were seeing each other in these last year is because of the dog. I got the dog for myself. I bought the dog when we broke up because I was going to be homeless and I wanted a dog. She knew this. When I got the dog and picked the dog up, I paid for the dog. She said that she didn't want to see the dog sleep outside, so we could stay there. And it was an off and on again thing where she would kick me out for a night and I'd come back the day, and and it was just on and off, on and off, on and off.
And then
Then I
you're
get my
sick,
daughter.
You have your dog and
Then
you have your daughter.
then I
did
get
you
my
your
daughter.
into your custody. When did that happen?
That happened in May. She came in May.
Of what
June.
year?
But she got
June of
here at the end of May.
2024?
She was here at the end of May, like the 29th of
All
May.
right. So, but these messages that you've handed out in hard copy
Yes.
came just a couple of days after a disagreement about the dog?
Yes.
Okay, all right.
Yeah. This is all most of the stuff is all over the dog, and why I won't come
Where
down and
is the
see it.
dog at the time? With you?
No,
With
the dog was with me
Gooding?
at this time, but she
Okay.
put the restraining order because, ma'am, this is my first time being a dog owner. I didn't know anything about registration or anything like
All
that.
right, I don't need to know about
Yeah.
the dog that much. I just
Okay.
need to understand here. And I know you talked a lot about the dog and whose dog it is and who should have it, and that's.
Well,
what
I just think
can
that it's not
determine
fair that
here.
she said that stuff and that I have to do all of this just to prove my innocence and to get my dog back. This is ridiculous.
Well, the court
I'm sorry. It's not.
here can't do anything about the dog and ownership there, just so that's clear to everybody.
Even if she lied, I'm just saying
I don't have the authority here to
Right.
pass property back and forth. And unfortunately, I know dogs are more than property, but under the law, that's how they're seen. And I don't have that authority in this case. I do have the authority to make a decision about whether unlawful harassment was committed by Ms. Gooding against you and whether this order should continue. So anything else before I turn to Ms. Gooding?
No, ma'am.
Okay, so Ms. Gooding, I don't have anything in particular from you.
Yeah, I'm still waiting
say-
for public records to come in. Sean's been pretty active this past week contacting me and calling animal services.
So this is the trial. So let me focus you in then. So you
Okay.
agreed to each other for about 3 years?
We were together for 4 years. We started
4
dating in April of 2020.
Okay,
And then we
and-
ended our relationship March of 2024, and we were
Okay.
still in an intimate relationship up until the end of February of 2025.
Okay, so you've heard this allegation about the Facebook posting, about the loss of a job. What do you have to say about all that?
So we can start, I mean, I'll start with the loss of the job.
I
Sean
want
did
to
in fact,
start with the Facebook
oh, the
posting.
Facebook post.
Yeah, tell me about,
So I really don't have anything to speak to it because I didn't make this profile. Like Sean's the one that's familiar with making many profiles, not me. My Facebook is typically deactivated. So that, I mean, that's all I really have with that. I don't know how else to dispute it. I know Sean's had not only access to my phone, but when his phone was broken, he accessed his Facebook and his Messenger on my personal cell phone. So like I as far as timeline goes, the it being created, like I don't have anything for you, Your Honor. Just that I did not make this
right.
profile and
So
it would be
you didn't make that Facebook statement that puts Mr. um, Valva as if he's a sexual predator, a
no,
rapist.
Okay.
no.
Well, then when I look at, all right, so then we've been looking at these text messages.
Yeah.
This is all filed in the court file for you to have looked at too.
I did
before.
see some, but there were just a lot. Go ahead, sorry.
So these that are being alleged that you made right before he was served notice of a hearing in Superior Court for an order to protect you.
Yeah.
Enjoy what little reputation you have. I'll have a profile for you made on every hookup site outlining what a fucking rapist you are and will lie about anything to trick women into fucking you. So what's all that? That's
That the
attributed to
only
you.
thing from like things that I have seen, like I said, I don't get on my Facebook. It's typically deactivated. So what I saw and assumed, I was just like, he probably just made a fake profile for me because he makes fake profiles all the time and
This
was
is a
just
text
having a conversation. So
This is a
that's
text message stream that we're talking about.
a text message stream.
Yes. I'll ruin your life and everyone you love. No one will want anything to do with you. I'll send your mom and Sally all your internet history so they know just how sick you are. The emoji with giving someone the bird.
Yeah.
Enjoy that, fucker. See you later today, bitch. Enjoy what little reputation you have.
So
You'll be a
what's
sex for the rest of your life, and then pretty vulgar sign off.
Yeah.
So text message stream. Tell me about that.
So the only thing that I can really think again is just like a back and forth. Like currently Sean is padding my text messages with like all of the fake information about this is about the dog in the car. Like this is all that this is about. And you're hearing a lot about it. It's all over the petition. Like Sean is upset that I'm the legal owner of this vehicle and Max, and he's going to any and all lengths to get him. Like you said it yourself, like you're not going to award Max, and all this is going to do is make Sean find any way to try and get this dog. And
So
so,
this getting then this back and forth on the text, that's what you're
yeah,
saying it's all about. You're bickering back and forth and pretty
I'm not
colorful and
saying
ugly
no. I
language.
am not saying that is me at all. Like there is so much here that I'm having to do work to like basically prove wrong and false. I'm not the one that got the citation from Animal Services. That was Sean.
Well, let
I
me
talked.
ask you about, have you had troubles with your phone service, with texting being attributed to you?
Yeah.
What? Tell me
So
about that.
I have had to like basically use a hotspot on a phone that is broken so I can use like another phone. For the last like 3 months, I had to I had to use my kid's phone because I couldn't get a new phone. So I've only been able to actually utilize my cell phone that I have, my iPhone, since it was right right when March 25th, because I had seen that Sean had gone to the district court for a petition. And I was like, I need a phone that works. Like, I don't have a phone. So yeah. And that's like all stuff that Sean has access to, and Caitlin. Like, they're always logged into my Wi-Fi. Caitlin's logged into her phone, into my Xfinity account, so she can get hotspots. Like, I'm not a very secure person.
So you haven't used your phone for how long?
Like 3 months.
You haven't sent
Oh, no.
text,
So it would
you've
be
had
since
phone
the
calls
25th
of what?
March.
Okay, so before that,
Oh, no, wait, Your Honor, I'm sorry. It was the 23rd, because Sean showed up at my
March.
house and I got threatening text messages from him on my phone, and I got it on my phone because it had just been repaired.
So before that, I'm not asking you to testify, Mr. Villalba, just sit quietly. I'm listening to Ms. Gooding and you're distracting.
Sorry.
So, Ms. Gooding, so before that, were
Yeah.
you using your cell phone to send text and phone mail and doing everything else on the internet?
No, like, I had my laptop, and then I had my kid's phone, but I mean, internet, like, I just go down to the library, really.
Okay,
Like,
so you were on
on the
communicating,
internet, yes.
like,
I
yeah,
was using the
right.
internet. I just don't have my Facebook activated.
But what about texting? How do you communicate with your children before that?
So I was using Instagram on my desktop, and like, we live together. So my child's 19. So we're in the same house, and we really don't have a whole lot that we text about, but I was using my Instagram message feature through there to send text to my kid. So I know it's really like MacGyver-y way, but I just like was actually enjoying like not having my phone and not having Sean contact me. Like, that's just what it is.
So when was the last time you received anything from, well, no, when was the last time you sent a text message to Mr. Villalba?
That would have been, oh man, that's a really good question. It would have been before he gave me the petition, because I could see in like the small fractured corner of my phone that I had gotten a text message from him. And it was the day that the petition was dismissed, my petition through Superior Court. So he had
Okay, so that's-
immediately texted me after it was dismissed and asked me if he could see Max. And I said, absolutely not, considering he had assaulted me last time I had seen him. So yeah. So I guess I should clarify, like, the using of my phone. It was really just like,
Well, I'm just
desperate
wondering, so
moment.
that was the last time you had a text message interchange, you're saying, with Mr. Villalba, was right after your hearing with the Superior Court, which was, looks like that was around the 18th of
Yes,
March.
and that was an exchange. And since then, Sean's texted me and there's not been an exchange.
Okay. All right. So you'll agree that whoever sent these texts knows a little bit about Mr. Villalba's family and the two of you?
Yes. Yeah. Especially if they know Aunt Sally, like, yeah.
All right. So anything else about these allegations?
So the losing his job, he didn't lose his job because of some profile. He lost his job because he was getting caught too much smoking fentanyl at work.
How do
And
you
so,
know that?
because he
Know
would
that.
tell me. He would like
Oh.
drop fentanyl pills in the porta potty and text me and be like, oh my gosh, like, I almost got caught, a pill rolled under. There were,
And so that was, how were you told that, by text or?
no,
what?
in person and by text. Sorry, yes, by text.
So
And it
this
would be
was-
like coworkers that would make comments, and they started like making jokes about him, and
All right,
it's
so,
not funny.
well, I need to know from you. So he tells you, so when he says he lost his job September of 2024,
Yeah.
when was all
That's
this
correct.
information coming to you from him?
So he was just really confused because what they told him was that work had slowed down. However, he was the only person that they let go. And like
How do you know
Sean's
all this?
intuitive when
How do you
it
know
comes.
this? Do
Go
you
ahead.
work for the company?
What's that?
How do you know this? Do you work for the company?
That's what Sean told me.
Okay.
And
right.
that's what he repeatedly was just going back and forth with, just like, I don't understand why. They said work slow, but there's people working on sites. And yeah, he said probably like a couple months ago that he ran into an old coworker and they told him that work had slowed down, that there was like a contract for an apartment building that they didn't get.
Okay. All right. Anything else about that?
No, that's it. I just wanted to clarify that piece that had nothing to do with the profile.
Okay. Anything else I should know from you, Ms. Gooding?
I guess I don't know when is appropriate to talk about my concerns with some of the procedural parts of this that have taken place, like the proofs of service or the service of the petition. Because I
Okay.
had both Shauna Case, who's an involved party, and Caitlin Villalba show up to my property to serve the petition. In addition to Caitlin Villalba showing up with another party, and unidentified adult female who stayed for 40 minutes, showing up at
What should I
9:50
do
at
with
night.
that information? Tell me what I should do with that information. You received
Well, I'm just
notice
confused
at
because the
today's
proof of
hearing.
service says that Shauna Case served me these, or like the petition. She did not serve me the petition. I was threatened if I didn't open the door to accept the papers, they'd call OPD, and they did, and it was OPD that served me this. So
Right,
I'm
I
just
saw.
wondering why Shauna Case is committing perjury by saying she's the one that served me the paperwork.
That's, yeah. You've
And
been
why are
served.
protected parties serving the petition? Like,
Yeah.
in
it's not
Villalba 16?
There, Ms. Gooding, it's not humor there. I don't have, this is about Mr. Villalba and about you and whether this
Yeah.
order should issue, and you were served notice by Olympia Police
Mm-hmm.
Department, was valid, and that ends that issue. Is there something else?
No, that was it. It was just curious why Shauna Case would be turning in a proof of service.
Yeah, all right. Okay. Let me kind of look through things and see if I have any questions for you or. So, Ms. Gooding, Mr. Villalba, I am issuing this order on behalf of Mr. Villalba, and the reason being, Ms. Gooding, is I do find that there's unlawful harassment committed by you against Mr. Villalba.
Okay.
I'm glad to hear that things stopped a few weeks before the filing of this petition, but I see even with these, the opinion that it's not real credible, though. These text message from that I've been served plaintiff's exhibits, it's somebody who knows a lot about Mr. Villalba's family, his mom, his aunt, knows all about the relationship, knows all about there's a problem. The threats to make a profile, to ruin a reputation, and then matching that up to the Facebook posting and the marketplace, I guess I'll call it, that details that to the world, shows, and I think, and I find credible information and sufficient information to attribute it to Ms. Gooding. And then, so I'm issuing this order. So what that means is through April 7th of 2026, you're not to have any contact with Mr. Villalba. And no contact with, as well with Caitlin. And it's up to, Caitlin's old enough to understand this, but Mr. Villalba, you need to also talk with your daughter and make sure she's not violating this order. Well, not violating the order, but putting Ms. Gooding in a position to have contact with her. What I'm making a finding of is that there is a course of conduct directed at you by Ms. Gooding that is causing, and I see it here in court, substantial emotional distress, and it doesn't have any legitimate or lawful purpose, and it's unlawful harassment. So your belief that that's going on, then don't engage in any contact with her, and talk to your child about contact with her that it shouldn't be had, as you've asked this court to issue this order. Now, if you believe there's a violation of this order, Mr. Villalba, then you contact 911, because the upshot could be an arrest and possible criminal case filed against Ms. Gooding. So just don't, go by this order. And so this will be in effect through April 7th of 2026. Mr. Villalba, if closing in on that time frame, you think this order needs to go longer, then we have to have another hearing. So within 3 months of that expiration, so January of 2026, you can come back to the court and ask for a hearing. And then we'll see if this order should go longer. But today I'm just going to issue this for a year. And then, so Ms. Gooding, no contact means no contact. Doesn't mean through family, through friends, through social media. Not with Mr. Villalba, not with Caitlin. She's covered by this order. Stay at least 1,000 feet away from wherever he lives, works, goes to school, wherever you know he is. And Mr. Villalba, you have something you wanted to say?
Yeah, I was just requesting that if she could please log out of my stuff so I can get my email back, so I can get my pictures, that'd be great, because if I try to get my emails, I have to send her email, a number, so I can get it back. I don't know why, but I can't get any of my stuff because she's still logged into my account as of right now. And I have proof of all of it.
You've changed passwords and all.
Yeah, I've done all, I have so many different login, logouts, passwords, and all this stuff. It's just so ridiculous. I mean, I have to get a new phone, so. No, we didn't share an account. She'd get into my phone when I'd go to sleep, and I'd wake up and I'd have like spyware and stuff put on my phone.
Oh.
I know, it's all right. It's all right. I haven't, yeah.
It may take something with your provider and may
Yeah.
take something, I don't know, I can't advise there.
It's all right. All right. I appreciate it, Your Honor. Thank you very much for your time.
So Ms. Gooding, writing up this order, do you have any questions about the limitations on you?
No, I just appreciate the comments made to Caitlin and Sean about their interactions with me. And I just would appreciate Sean to stop contacting me and filing false animal services reports. They know it's you, Sean. God.
All right, I'm not asking you to argue over Zoom and during this hearing. So I asked if there were any questions about your restrictions.
No, I have none. Thank you for the order. I really do appreciate it.
So that's all for today. It'll be in the court file and available to you. Service is not necessary as you appeared, and you can get a copy of this through your Zoom instructions and or calling the court.
All right, so I rewatched the whole thing as I was like sitting here doing other stuff, right? I was, in and out listening and stuff like that, but I was watching her more closely than I did when I first saw this. And now it makes sense. Yeah, she is a bit kind of smug. You can see she's a bit kind of smarmy, as we would say here. I don't know. Do you say that in other countries? I don't know. But yeah, clearly this lady's an absolute, Actually, you know what? The only B word a woman should be called is beautiful. Bitches love being called beautiful. But yeah, clearly you can see that obviously the guy's got some issues, maybe drug and alcohol issues, mental health issues. She seems much sharper than him, but clearly she's manipulative. You can really see that. Now, maybe I'm wrong. Maybe the judge is wrong, and maybe, the crazy guy's wrong. You let me know. What do you think down below? Was the judge right to give this order? Did you believe him or her? Are they as bad as each other? Probably. Anyway, lads and lassies, thank you so much for joining me. I hope to see you back here for the next one. Sláinte Mhagat Míle Maith.
So, ma'am, unfortunately, you leave me no choice, but the court will sentence you to 30 days in jail. Ma'am, you can go with the sheriff, and
Are you
this matter
serious?
is concluded. You're free to go.
Who's
Have a good
sucking
day.
who's around here?
Hold-
No,
ma'am,
seriously.
Another 30 days for contempt of court. You're in jail for 60 days now.
This is our fourth motion to try to get him parenting time. We simply want him to have his parenting time. With the threshold being met, Your Honor, and considering the behaviors, and I think it's gonna be ongoing from this couch. We request that the children be turned over to him today.
Okay, we are on the record for case number 2024-1372 DC. Zachary Conley versus Athena Couch. Today is Wednesday, March 12th, 2025 at 8:54 a.m. Attorney Michael Kelly for the plaintiff.
Good morning to everyone. This time and place set for the show cause hearing in this matter for contempt for failure to provide parenting time. I'll let you know, we're going to take some brief, I guess, testimony from the parties. I'll let everybody know that everybody will have an opportunity to speak, so don't interrupt anyone else or don't interrupt the court. You'll have an opportunity to speak your piece. So on the we do have the show cause hearing. We also have the motion for change of custody and parenting time. I'm going to address the motion first because that will be the easiest matter to get resolved. So, Mr. Kelly, you can proceed with your motion.
Your Honor, essentially, that motion is based primarily on the issues we've had ongoing in relation to compliance with the court order and my client getting parenting time. It's directly and impacts the child custody factors, and I'll name the ones that are impacted due to this withholding occurrence. The love, affection, and emotional ties existing between the parties. It looks at the emotional bond. Him being prevented from seeing his kids is preventing him to continue that emotional bond and nurture that emotional bond, which he had prior to this latest withholding that has started back on December 27th. Factor B, the capacity and disposition of the parties involved to give the child love and affection that focuses on the ability to, again, parent to foster an emotional bond in the future. He's having a hard enough time in the present, again, because she's not keeping in compliance with the court order, and he's not able to see these girls to be able to have a solid relationship and foster that relationship. The length of time they've lived in a stable, satisfactory environment, I'd submit to the court. Defendant's home is not stable, considering the allegations she's made that have been investigated by CPS twice, police twice, and both been denied. Nothing's come of it, which leads me also to the moral fitness of the parties involved, which ties into the same factor. But we have to keep in mind, Your Honor, at the beginning of this case, he was charged with domestic violence in relation to her essentially going after him to get keys to his truck so she could get some pot and smoke it. As he's being arrested, she's telling him, "I want you to come home." He, of course, gets him on bond. He can't have any contact. Once the bond conditions get lifted, she's contacting him through text and saying, "Hey, let's meet you and the girls get together and we can go to the zoo, we can go to a park."
Okay, Mr. Kelly, how does this relate to your motion?
It's related to, Your Honor, again, the moral fitness involved, as well as the stable, satisfactory environment, in that she's accusing him of sexually molesting these girls. But before all this, she's wanting him to come home. She's wanting a relationship with him. She's wanting her family essentially reunified. Those two things don't jive together, Your Honor. And I would think that essentially it's a fabrication, which would go again to the moral fitness and also to the mental and physical health of the parties, Your Honor. You're making these allegations, these terrible allegations, but on the other hand, you're still wanting the same guy who's supposedly doing this stuff to come into your house. Finally, Your Honor, the unwillingness and ability to facilitate and encourage a relationship. Again, this is the fourth motion we're here this morning on, Your Honor, for him to see his girls. She doesn't follow your court orders. She withholds them for no valid reason. And She's clearly shown she's not gonna facilitate a relationship between him and his kids. I think that's more than enough that gets us over the threshold of a change in circumstance or proper cause, because these things are having a significant impact on these girls' lives in terms of having a relationship with their mother. So we would request, as part of our relief, that you set this matter for an evidentiary hearing. We're also requesting during the interim that my client get temporary parenting time starting today, and that he continue to have them until the evidentiary hearing. That mom's parenting time be supervised at her expense, because she's clearly shown an unwillingness to follow your rulings or to comply with your court orders. I think if you don't do that, she's gonna take these kids and run, and we're gonna be in a bigger mess than we are today.
Okay, thank you. Ms. Couch, if you wish to speak to the motion.
I had some statements, but it's just what I had submitted to the court.
Okay, go ahead, tell me, and then
Okay, would you like me to stand?
whatever you wish. If it's more comfortable sitting, go ahead, but speak up a little. So we can-
Okay, I said that his first statement was true, but the second statement that he said was false. I said I previously tried to change parenting time because of the videos the plaintiff had been watching. It was reported to Penfield's police department because plaintiff was previously residing in Penfield. I spoke to their sheriff where we looked at the videos together, and he told me that he would be conducting a search and not to address the matter to the plaintiff because he would need time to get 2 search warrants, and the investigation was never done. The next statement is also false. On December 27th, after the children's bath, Amelia Conley was heavily touching her private area, and when questioned who touched her potty, she said her dada. On January 1st, Evelyn Conley stated that her dad touched her on the couch. The fourth statement is false. CPS is not taking the proper steps to ensure the minor children's safety, and I did mention police involvement in the last hearing as well. The fifth statement is also false. Errors were made by the plaintiff's attorney. The sixth statement is also false. There is supposed to be a pending CPS case, and I was never told otherwise. CPS and I have spoken on numerous occasions and decided that the best course of action was therapy, which the minor children are attending at Summit Point. I do have proof of all of that as well. That's also false. I was never told that they were declining to investigate the police. Number 8. It's false. In early 2024, my mom threatened to call CPS on me because of the children's odd behavior, requesting that I get them checked by the doctor. I had the doctor examine them at their 2-year checkup, and almost 2 months later, the plaintiff was arrested for domestic violence. I originally withheld the kids because of the plaintiff's sexual preference for diapers and enemas, knowing that the plaintiff was not mentally stable enough for unsupervised visitation. And I withheld the children again after finding videos the plaintiff had watched of children being abused. And the minor children were sexually abused during holiday parenting time with the plaintiff. The 9th statement is true. The 11th statement is false. The 12th, I'm unsure of the plaintiff's employment, but the plaintiff has stopped paying child support, and I still stay at home with my children. Number 13, I have lived at the residence that the FOC has on file since December 10th, 2024. The 14th, statement, I'm unsure of the plaintiff's relationship status. I have friends and family in Michigan, and I lived in Indiana until I was 18, and most of my family resides there. Number 15, I would like the court to consider changing the current custody orders and issue no further contact between the minor children and the plaintiff. Plaintiff should be held accountable for his actions regardless of stature or representation. That's all.
Okay, thank you. I don't need anything else, Mr. Kelly. What the court will do in this matter is the court has read the pleadings. Obviously, you're well aware of the file in this case. The court does believe that the plaintiff has met the Vavarka threshold of proper cause, change of circumstances sufficient for an evidentiary hearing. So the court will schedule an evidentiary hearing in this matter. Mr. Kelly, you can proceed with your show cause hearing. Do you wish to take testimony from your client? Okay,
Certainly can. I have another witness that I could call as well. I just had 2.
okay. Whichever you want to do first, go ahead.
I could have Mr. Conley
Okay,
testify.
Mr. Connolly, if you step forward, we'll have you sworn in and then we'll take some testimony. And I say brief testimony, I don't need to get into.
Sure. We'll keep it straight and to the point here.
All right, raise your right hand, please. Do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
Go ahead and have a seat, sir. Go ahead, Mr. Kelly.
Mr. Conley, could you state your name and spell your last name for the record?
Zachary Donald Conley, Conley.
Are you the father of Amelia and Evelyn Conley in this matter?
Yes, I am.
Okay. You currently have parenting time with them.
Yes,
What is your understanding of what the parenting time is supposed to be?
every other weekend and a day during the week, in the evening. Not my weekends, it's Wednesday through Friday.
Have you been getting your parenting time?
No,
Why not?
because she is refusing to let me see them.
And when you say she, who are you referencing?
Athena Couch.
Okay. Have you attempted to get your children from this couch?
Yes,
Have you called the police for their assistance?
yes.
What happened when the police got involved?
That she slammed the door in their face, denies them, and just tells them no.
Have you filed motions with the court to get parenting time?
Yes,
Has the court awarded you make up parenting time?
yes,
Most recently, did the court award you parenting time in January of this year?
yes,
Did you attempt to go pick the children up for that make up parenting time?
yes.
What happened?
She refused to give them to me again.
Do you approximately know how many days you have missed so far as simply your overnights for parenting time?
20.
Would you like the court to grant you some make up parenting time this morning?
Yes.
No further questions, Your Honor.
Okay. Ms. Couch, do you have any questions for the plaintiff? No? Okay, thank you. You may step down then, sir. Next witness, Mr. Kelly.
Your Honor, we would call Lori Connolly.
Okay, Ms. Conley, step forward, please.
Lori Putnam, Your Honor.
Okay. You're gonna make me change my,
All right. Ma'am, do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
Yes,
ma'am, could you state your last name again?
Putnam,
Spell.
Putnam.
Okay, thank you. Go ahead.
Ms. Putnam, how do you know Mr. Connolly?
He is my son.
And how do you know Ms. Couch?
She is Zach's former girlfriend and the mother of my granddaughters.
You heard him just testify that he has parenting time with your granddaughters, correct?
Correct.
Okay. Do you assist him in pickup and drop offs for
I do.
parenting time? Okay. What do you do in that regard?
I go with him and walk up to the door with him. To get the girls,
Okay.
to attempt to get the girls.
Has there been occasions when you have gone with him to go get the girls? And anything happened in regards to him actually getting the girls?
Prior to December 27th, yes. After December 27th, no, she refused.
Let's talk about prior to December 27th. What would happen?
We would go, then we were meeting at Riverside Park. And we would wait for her to show up. When she'd show up, she'd let the girls out and they would come running up to Zach and we would take them.
Okay. Did something change after December 27th?
She just started refusing to give the girls. His first visit that he was supposed to was, I'm not sure, but I got a text from Athena on New Year's Day saying
Okay.
that she was gonna refuse to give the girls.
And have you gone with him on subsequent occasions to attempt parenting time?
Yes.
Okay. And what has happened on those subsequent occasions?
Either she would not be home, he would text her and she would not respond, or if she was there, We'd knock on the door, she'd open the door and then just say no and slam the door in our face. So we would go back to the truck and call the police for the police to come out and assist.
And the police came out and assisted that help in terms of actually getting parenting time to occur.
No, she just did the same thing to the police.
No further questions.
Hold on, ma'am. No, you're not done. Just to clarify, that he talked about prior to the December 27th date, and the court had previously entered an order which provided for makeup parenting time, and that stated that the parenting time would that the parenting time would, again, the makeup would occur on January 27, 2025. And the plaintiff's motion states that he did appear on that date. Did you go with him on the January 27th date?
Yeah.
Okay. And what happened on that date?
She just refused. I don't know, either she refused or she wasn't there.
Mhm.
Okay. And you don't remember if she was not there or if she refused?
I don't remember that specific time.
Okay.
I have it written down at home, but I don't remember.
Okay, Ms. Couch, do you have any
I
questions
do,
of this witness?
yes. Um. At what age did Zach Conley start wearing diapers?
And Judge, I'm gonna object to it.
Ma'am, that is not germane. What
No, I am.
Ma'am, what we'll do is we're here to determine whether there was parenting time. That's the show cause, okay? So that's what the purpose of this hearing is. So you can ask questions about the parenting time, compliance with the orders, etc. Okay?
Okay,
Go ahead.
and you were at my residence on the 27th to pick up the children?
Oh, actually, on the January 27th?
Yes, or
Yes.
December 27th. Or sorry, no, January 27th. I don't have anything written down.
Yes.
Even though the order was for the 29th. Wasn't that the order
Whatever,
that the judge put
whatever
in
day,
place?
whatever judgment day.
So
I
you
don't know
just,
specific dates, whatever.
and I slammed the door in your face how many times?
Twice that I went by myself once because that was at an appointment that
And,
you slammed the door in my face. I have it on video, yes.
and you came alone, correct?
I did that day,
Okay.
yes.
And then, that's all. That was all I have. I'm sorry.
Okay, Mr. Kelly, any redirect?
No, Your Honor, no further questions, no further witnesses.
Okay, you may step down then. Thank you. Ms. Couch, do you wish to present any testimony or witnesses? No? Okay. Check that order because there was some. Ms. Couch, you raised some issues concerning the I think it was the order of January 27th. I want to make sure if that was the time as well for the makeup parenting time. I believe it was, but
It was January 27th through February 9th.
okay, that's what I thought. And
I could have swore the pickup date was the 29th. I apologize.
well, I want to make sure that it's correct so that there's no issue.
But I was not home at the time of pickups
And why is that?
because he has sexually abused our children. And I don't believe that he needs any more parenting time.
You understand that there's an order for parenting time.
And if it was your children, you would be sending them with him?
Yeah, I'm just asking you a question. You understand that it was parenting, that it was ordered.
Didn't you deny that? Didn't you go on base and deny it after the fact?
Not the other particular orders. I did deny an ex parte order at one point, but there were subsequent orders to that.
You guys did receive the pictures that I submitted to the court as well, correct?
Anything that was filed has been in the file.
I would love you to take that into consideration.
I would know for the court, I received no response to either of these pleadings for today's hearing.
Okay.
You got two in the mail.
Okay, the order is dated February 4, 2025. And it provided for makeup parenting time in Christmas Eve, Christmas Day, 2025. It also provided that the plaintiff would have the children with him on January 29th, 2025 at 6:00 p.m. until February 9th, 2025.
I have another question to ask you, sir.
Okay. Let me clarify that, because this is the order dated February 4th. Did you provide parenting time on the January 29th?
No, I did not.
Okay. And we had at the last hearing and addressed the issue of the CPS involvement. CPS, as Mr. Kelly has stated, has been involved twice before, and they've not had anything substantiated. Is that your understanding?
No, I have the CPS report right here, as well as Carla Titus's number. Now she said that her findings weren't. I need to take the kids to therapy, to get the whole picture, from the kids, them talking, them playing, them, interacting with a therapist. And so that way they can go, they can go on record. And they are in therapy at Summit Point. Now this is just started, but they've already, said some things. That was one of my questions. Do you have the report from Summit Point? They told me that I needed to sign a release so that way they could contact you.
Okay, I'm not aware of any report from Summit Point. It may be in the file, it may not, but you've not introduced that today. And you don't have anyone that could speak to that from Summit Point as a witness in this case, which is what today's date is set for in this particular matter. So that is okay. Mr. Kelly, do you have any final argument in this matter?
As the court's already touched on a little bit. This is our fourth motion to try to get him parenting time. We simply want him to have his parenting time. With the threshold being met, Your Honor, and considering the behaviors, and I think it's going to be ongoing from this couch. We request that the children be turned over to him today, that he have custody and parenting time with the children until the evidentiary hearing occurs. We request mom's parenting time be supervised. We'd also request the assistance of law enforcement to pick the children up. I believe they're probably with her mother, who's likely going to take the same stance as Ms. Couch and refuse to turn them over. Maybe give them the authority with a court order if she fails to do so, that she can be arrested. And in the meantime, Your Honor, we'd request a finding of contempt. Sanctions are doing nothing. You've sanctioned her $1,000, which she's a voice she's never going to pay. Doesn't have any impact on her. At this point in time, we request jail time. 30 days of jail time. Maybe that'll get her attention that she needs to follow your orders. Thank you.
Thank you. Ms. Couch, your closing argument.
I am acting I just want my kids to be safe. That's all.
Okay, thank you. Well, the court has heard the testimony in this case. The court will note that, again, that apparently there had been denial of parenting time, which is not disputed by the defendant. In fact, she acknowledges that she has in fact denied parenting time. And court notes that as a result, she has withheld the children, that she's failed to comply with the order of,
But there's reason, sir.
excuse me?
There's reason,
Okay.
valid reason.
Okay, ma'am, you're done. You don't have time to speak at this point. Okay, you've had a chance to testify, you had a chance to do a final argument, so you're done. The court, she failed to comply with the order of June 13, 2024 for parenting time. She failed to comply with the order of December 2nd, 2024 for parenting time. There was an order of November 1, 2024 for makeup parenting time and attorney fees of $500. Again, there was an order for makeup parenting time dated February 4, 2025 for makeup parenting time and attorney fees from the hearing held on January 27, 2025, that all four of those orders she's failed to comply with. The court has reviewed the file. There's been multiple show cause hearings. She has previously been held in contempt of court. She has previously been ordered to make up parenting time as well as pay attorney fees, as I stated, and she's failed to comply with any and all of these prior orders of the court. Her recourse is to file motions, have hearings in the event that there is some issue. The court will note that I am recalling from the last hearing where she had made allegations concerning the plaintiff, and in fact, she acknowledged at that time that there had been 2 CPS involvements and the CPS had not done anything as a result. She acknowledged that she had been in contact with the police, that they had not done anything as a result either. The court will find that she is in fact in contempt of court. The court will, as the plaintiff stated, he's entitled to 20 days of makeup parenting time. And that shall occur at such time as he acquires the care of the children. The court will note that, again, the prior rulings of this court, that she had done makeup parenting time on 2 occasions, as well as paying the attorney fees, that in fact, she has ignored and refused to comply with those particular orders. So, ma'am, unfortunately, you leave me no choice, but the court will sentence you to 30 days in jail with the Calhoun County Sheriff. The court will further remand you to the care of the Calhoun County Sheriff, where you will remain until such time as the children are turned over to the plaintiff and until such time as you paid the previously ordered attorney fees of $1,000. So, ma'am, you can go with the sheriff, and
Are you serious?
this matter is concluded. You're free to go.
Who's
Have a good
sucking
day.
whose dick around here?
Oh,
No,
ma'am,
seriously.
Another 30 days for contempt of court. You're in jail for 60 days now.
No, what's
If
going
you
on?
keep going, I can go as long as you want, ma'am.
Your Honor, if we could have the assistance of the sheriff taking out where the girls are, we suspect they're with their with grandmother, but we're not.
Well,
100%
she
sure.
has been remanded until such time as the girls are turned over, so that she can stay there as long as she wants, I guess, until she has them turned over.
I'll draft the order in 7 days, Your Honor.
Okay, thank you.
Thank you, sir.
You're free to go. Have a good day.
I can see you, Ms. Double. I can see you rolling your
That's right.
eyes. And I don't appreciate the fact that you are utilizing quite a huge amount of community resources and being flippant about it. Parents concerned by this case as well as the children. May I have the names of our participants, please?
Lee Heiss, lawyer guardian ad litem. Nastasia Thomas, counsel for the department. Chelsea Grant for the department.
Katerina Dumont, cover for Ariel Bridges, your faith double mother.
Faith Double, mother.
Michael McFarland, representing father, Mr. Patterson, please introduce yourself. Jeffrey Connor.
Alexis Stang on behalf of Austin Doobie.
Father.
Welcome. Ms. Heiss, whenever you're ready.
Thank you, Your Honor. I visited with the children face to face, and in this reporting period, we were all pretty worried about Mr. Doobie. And now that we see that he's okay,
he was missing in action and it was pretty stressful for everybody, but now we have him back. I visited these children face to face in their home. I had visited them at daycare prior. A lot of progress, although I don't know where they started from. I've worked with Mr. Patterson in the past and never really had the opportunity to see inside their family home. They're very cooperative. They're very, see a nice household. I see kids that are bonded. I see Mr. Patterson doing parenting. You know, I don't always see that because mom looks like she does an awful lot around there. You know, all these teeny tiny little kids and they eat at a little table set up so they don't fall and all that kind of stuff. I see a very child-focused home. The dog even behaves very well. But anyway, all their needs are being met, and these children are out of the home at daycare and at school. So there are extra eyes on these kids and extra people for evaluations and for their safety. Mr. Doobie's issues make me think that we're not completely settled, but other than that, the family seems to be cooperating and progressing in services, and I really can't say what could be done differently or better. So at this time, I think I will conclude with those comments. Thank you.
Thank you. Ms. Thomas.
Thank you. I'll call Mr. Doobie.
Mr. Doobie, please raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Good morning, Mr. Doobie. Can you hear me okay?
Yeah, I can hear you.
I just want to ask a couple questions about the court report, okay? Did you have an opportunity to review the court report?
I read most of the big packet that I was given by Chelsea.
Okay. And generally it says that during this review period, you have not been very compliant with your case service plan. Do you agree with that?
Yeah, the last thing, I relapsed. The last thing I did is I went to go get the counseling services, and right before I could get that set up, I ended up back out in the streets. So.
Okay.
You ended up what?
Back out in the streets.
Back out in the streets? Is that what you said?
Yep. That's what I said.
Okay. It's breaking up a little bit from your microphone over there, so I apologize. I want to make sure I understand what you're saying.
Yeah.
The court report. Okay, so briefly, the court report indicates that you are to serve 60 days in jail, with I believe that your start date's on 9/20, and then after that you'll do a 3-month day program at dog farms for substance abuse. Is that accurate to the best of your knowledge and understanding?
3 months, yeah, yeah. 60 days from I thought it was the 23rd, but the 20th would be better. And then 3 months at dog farms.
Okay. Well, one or the other. So 60 days from whatever your date of incarceration is considered or time served, and then dog farms. And is that something that you are committed to completing, that program at dog farms at this time?
Yeah, I am. I already filled out the both packets that Emily sent me. So that way I can get in right away. I don't have to wait.
You understand that some of the referrals that were made for you, like your psychological evaluation, that will have to be redone. Do you understand that?
Yeah.
Is that a yes? Just we're making recordings, we just have to have you verbalized.
Yes, yeah, I understand that.
Okay. Is there, I know that you're kind of in a tough situation being incarcerated, but is there anything that the department might be able to do while you're incarcerated to assist in compliance with your case service plan?
I'm not sure. I've been signing up for AA and stuff. Chelsea asked me to do that, so other than I don't see what you guys could do on the outside for me.
Okay. I will recognize that in your bonding assessment, it seemed that there were no real concerns about your parenting, but more of the concern is your other choices and how it impacts your ability to parent. Is that fair to say?
Yeah, yes.
Okay, I have no further questions, but other attorneys may, okay?
Okay, Ms. Stang, any questions?
Yes, just briefly. Mr. Doobie, you testified that you signed up for AA. Did you also sign up for NA services as well?
No, I've only received a paper for AA. No.
Okay. Do you know when those classes will begin that you're going to attend?
They host them every Friday, but it's not my choice if I go or not. The sergeant picks out who goes.
Okay, so have you been able to attend yet at all then?
No, I told him it was important and that I was requested by Chelsea to go, and I haven't heard anything, but I've been still signing up to just to you know, just in case he picks me one day.
Okay. Have you received any papers or anything yet regarding parenting education?
No.
Okay. If you receive those from the department, do you intend to read them and learn as much from them as possible?
Yeah, if I get them, I'll read them.
Okay. I have nothing further. Thank you.
Any questions, Mr. McFarland?
No, thank you.
Okay, what about you, Ms. Dumont?
No, Your Honor, thank you.
Ms. Heiss?
No, thank you.
We're good, thank you for your testimony. Ms. Thomas, your next witness.
I'll call Ms. Stubble.
Ms. Double, come on up for a witness stand.
You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
There's a step here, be careful.
Morning, Ms. Stubble. So just some of the similar questions I asked Mr. Doobie, were you able to review the court report for today?
I read almost all of it, yes.
Okay, and generally speaking, it states that you're pretty compliant with your case service plan. Do you agree with that?
Yes.
Was there anything in the court report that you did not agree with?
I mean, some of the stuff that was on the psychological, but I just want to get this over with.
Okay. Your psychological, I know that you don't necessarily agree with it, but the report indicates that it has been provided to your therapist, Mr. Quinlan, or a therapist?
Chris?
Yes.
Yeah.
And that you guys are working through that, is that accurate?
Yes.
Okay. I want to thank you for taking the kids to their appointments for the CTAC.
Yes.
It's a hard thing to get into and it helps the court know what's going on. Okay, so thank you for that. As Ms. I said, it seems like you're doing a lot, especially for your kiddos. Is there any area that you still feel like you need assistance with?
Not really. I'm just kind of getting used to like, before I've always had Jeff at the house to help me with the kids. So it's been a little bit different. I've just been getting used to, but I found they actually listen to me better without Jeff being there. So it's just kind of getting used to the new schedule, I guess.
One of the things that's noted in here is the continued contact with Mr. Doobie. Is there anything that you can help us understand about that? It seems that it's part of his probation that he's not supposed to contact you, but do you guys have contact still? I know that he's incarcerated now, but prior to that?
Yes, I have had contact with him.
Can you help us understand like the why? Is it related
like
to the
why
children?
do I talk to him?
Yeah, is it related to the children or is it or your?
I mean, we talk about the children. I told him that his son had school pictures. I mean, we don't talk about just like one thing.
Sure. As relates to the children's trauma assessments, were you able to review those recommendations?
Recommendations, no. Apparently not.
That's okay. There's a big court report, and there are several pages in each of the trauma assessments. But in that trauma assessment, there are also several handouts and resources. Did you review any of those?
No.
With that, I have no further questions.
Questions, Ms. Stang?
No, thank you.
Mr. McFarland?
No, thank you.
Ms. Dumont?
Ms. Double, once you're able to review those trauma assessments of the children and there's a recommendation, are you willing to look at that recommendation and see if that's something you would like to implement in your children's lives, such as counseling or?
Well, we already have the in-home therapist that comes. Like, I don't know exactly what their recommendations were, but I pretty much follow everything that's in my case service plan. I do everything that I'm supposed to do. So I don't know what she could possibly recommend.
Okay. Okay.
Ms. Heiss?
We had a family team meeting where we talked about these trauma assessments for the kids. And then at the end of the trauma assessments, there's a list of things that each child would need in a perfect world. So those are the recommendations that we're talking about. Are you willing to take another look at those and read them again?
Yeah.
And then after that, there's some books and some articles that are listed so that you're familiar with those things. Do you understand? In a perfect world, you would read all that stuff and know it all. Yes.
Yeah.
Okay, so I just want to be sure that we're clear. You have what you need to look at those things. I think it's your plan to keep the kids enrolled in school and in daycare where other people are giving them therapies that they need.
Yeah.
So like ISD will pick up at some point because some of the boys don't speak very clearly.
Yeah.
I think the boy that's name begins with a B and the boy that begins with an M. Well, we're on video, so.
Oh.
So
Okay, sorry.
B and M don't seem to speak very clearly, or is it me?
The last time he got tested, they said that he tested out of all services, that he didn't need any services. I'm thinking maybe since he's gotten a little bit older, it might like be borderline maybe. I mean, I'm not saying that he's way off of where he should be. He's definitely not. But Malachi, yes, we've been struggling with that for a while. I don't necessarily think it's because he's autistic. I definitely don't think he's autistic. I just think that kids have been through a lot.
Yeah. And when you say Jeff isn't there, he's working now, right?
Yeah, well, he was working before. He just changed jobs to a better paying job. One that he likes better, apparently.
And then you work during the day too?
Yes.
Okay.
I work all the time.
Okay, and then I don't think I have anything else. Thank you.
All right, Ms. Thomas, any redirect?
No, Your Honor.
Any recross from any of our attorneys?
No questions.
All right, thank you for your testimony. We return your seat. Your next witness, Ms. Thomas?
Jeffrey Patterson, briefly, Your Honor.
Mr. Patterson?
You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Stop.
Morning, Mr. Patterson.
Morning.
Did you have the opportunity to review the court report that Ms. Grant prepared for today's hearing?
I skimmed over it.
And based on what you've skimmed, do you have any issues with what you reviewed? Anything that you felt was not accurate?
About 95.
Can you scoot up to the microphone a little bit and, did you
About
s-
95.
About 95%, 95. Can you clarify that? It's 95% accurate?
Yeah.
Okay. Generally, it says that, you know, you're either compliant with or in progress with some of with essentially all of your case service plan. Did you agree with that part?
Yeah.
What was the 5% you did not agree with?
Are we talking about just mine or in a general whole?
For your portion?
Oh, well, then it's about 95, yeah.
Okay, so it was the 5% you did not agree with?
First.
Oh, okay. So for yours, your portion, you believe that that's accurate? Okay. And Ms. Hubble just testified that you are currently working in a new position, so, okay. And are you working more hours, it sounds like then? Or just different hours?
There's different hours because normally before I'd get up at like 4 in the morning and then be back out at work at like 2:30. Now I'm going in at noon and I get out at 9. So it's just different hours, but it's better pay. It's less wear and tear. It's just better in general for me.
And how do you feel IHG has gone for you?
Good.
Okay. Do you feel like you've benefited from that service?
Oh, yeah.
Did you have the opportunity to review your children's, I think one of your children had
Yeah.
a CTAC?
Did you?
I guess 2.
And,
Did you have an opportunity to review those?
yeah.
And are you
There's a lot
familiar?
on there that we've already engaging already, and there's more that still needs to be continued.
Wonderful, thank you for answering that.
Yeah.
At home, is there anything that the department could assist with that might make things easier or better at this point in time?
I think we're engaging in pretty much almost all the services that we can attend at the moment. We finish one and then we can have more time for another one. Nope.
I have no further questions, Mr. Patterson.
All right, hang on. Questions, Ms. Stang?
No, thank you.
Mr. McFarland?
Do you think that Ms. Double covered that 5% that you dispute in that court report?
Yeah.
Is there anything else that she didn't cover that you want to mention or not?
No.
Okay. Is there anything, it seems as though we're progressing very nicely, but is there anything else that we can do for you to help you progress better that you can think of?
Let me know if there's anything else you want.
You have a pretty good relationship and good contact with the worker, right? So you're just asking that if there's something else that she reach out to you, is that right? What's the best way for her to reach out to you?
Well, now it's going to be through her because my phone doesn't work right.
So you're saying that she should reach out?
About 2 weeks.
So through Ms. Double, correct?
Yes.
Gotcha. Okay, I'm glad we have that. And I have no further questions. We'll see if anybody else does.
Ms. Dumont?
No, Your Honor.
Ms. Heiss?
No questions, thank you.
Thank you for your testimony. May I return to your seat?
Thank you.
Anyone else you'd like us to hear from, Ms. Thomas?
Your Honor, I'll call Ms. Grant to tell you the foundation for the report.
You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do. Thank you, Ms. Grant. Today you have prepared a court report with several attachments. Since you've prepared this and circulated it, are there any other documents that have been circulated?
That have been since?
Yes. Okay. Generally, the Ms. Double and Mr. Patterson are compliant with their key service plan, and we've heard from Mr. Doobie about his lack of compliance. At this time, what is the risk if the court were to close out its jurisdiction and permit the family to move forward without additional oversight?
So we just have a few things within the court, or I'm sorry, the case service plans and the CTACs that we're finishing up with. I know that Faith had stated that she had it reviewed, but we did have an FTM. I think she just is overwhelmed with the amount of things going on. We had an FTM and we did go through each and every individual recommendation on all of the kids' CTACs. And that included the parenting classes that they're currently finishing, following up with through the National Trauma Assessment Center. That were recommended for all the children's CTACs. Additionally, there is just a couple things for M that we're kind of working on to finishing up. Overall, they're doing well. The biggest thing that would be the concern right now to end today would just be setting up forward for the future in both psychologicals. I know that they had stated they didn't agree with a lot of it, but it also states that once structured supports were removed, that there's concerns that old habits would kind of fall back into place. And I want to make sure that we get the rest of that structure for them set up so that we're not back here in the future.
As relates to Mr. Doobie, while he's incarcerated for the next 60 or so days, what resources can be provided to him?
So we're going to work on getting him the workbooks for parenting education that he's able to do while incarcerated. We will not be able to complete like a psychological referral while he is incarcerated. The person who he was referred to previously doesn't take re-referrals because she's virtual and due to the no-show rate. However, so he would have to be referred to somebody that does in person. Being that he's incarcerated, he is not able to obtain that at this time, although I could reach out to her and ask again if she would be willing since he is incarcerated. Sorry, I lost track of the rest of the question. I apologize.
Just what services you could provide to Mr. Doobie while he's incarcerated?
Yeah, so sorry. So there were those two on the list, and then additionally having him complete the AA that is offered. He had reported that there might have also been NA offered to him while he is incarcerated. So starting there and then moving to his substance abuse and mental health treatment when he is released.
Is there anything else that you would like to highlight from your court report or any of the attachments?
I don't think so.
In addition to IHT, are there any other therapeutic services that the family may need or benefit from?
So Jay will continue to see the in-home therapist. He will do individual along with family therapy as IHT has ended and they're working on that transition. Faith and Jeff had to get insurance. Faith's insurance will cover her and the family therapy for JJ within the correct plan. The issue we're going to run into is the barrier for Jeff due to the fact that all of the children through Medicaid are claimed under Faith. And my understanding when I followed up is that the program through Medicaid that Jeff qualifies for is a very basic program. It doesn't cover a lot of mental health, medical treatments, those kind of things. It is a very basic, there's really no appropriate way to say this, but it's really more for females who are pregnant with reproductive than it is for general medical. So it's really trying to find a service provider that will take that, as there's no way for him to change his plan because he doesn't have any children that he claims on taxes. So until that time, which isn't until, January to April next year, he's probably going to be stuck in this medical plan until that time.
Is there any referral sources or is this something that the department may be able to cover
in the meantime
in some other fashion?
So that's something I'm gonna have to talk with our funding to see if we can draw up like an individual contract for him to handle like the last individual things. He would not be able to see Mr. Quinlan, who sees JJ and Faith due to conflict of interest, but Chris was more than willing to do any referrals for Jeff or somebody within, you know, the Parkside unit that would handle that. So it's something we're gonna have to explore. The insurance issue finally came to light when they were approved within the last 2 weeks. So we've been working on that pretty diligently to see if there was a way to switch his plan or anything else like that. Faith and I had actually just been talking about it Thursday, Friday last week, and I got an answer from like an upper manager late Friday afternoon. I was able to review this morning before coming in, so.
And generally, if everything indicates the children are generally doing fine in their parents' care or with Faith and Jeff at this time.
Correct.
And as relates to Mr. Doobie, we know that he's been incarcerated, and then there'll be this substance abuse program that he's going to need to complete. What would be the parenting time recommendation in the interim before we come back for?
If he is able to have them, at Lenawee County, I don't think they allow parenting time while he's incarcerated there. Following that, he'll be going to Dawn Farms, and I'm not sure what their, I guess, allowance or parenting time on that is. I would have to follow up with them regarding that. One thing in the CTEX was that he was not having parenting time until he is engaged in doing part of his substance abuse and youth service plan. So as long as he is engaging and making progress, we can look at supervised parenting time, depending on what it is at Dawn Farms. If it's once a week, twice a week, obviously it would be supervised, but a lot of it is going to depend on their policy and procedures also.
With that, I have no further questions of Ms. Graham. I move to admit the report with the attachments.
No objection.
No objection.
No objection.
No objection.
Thank you. They are received. Questions for this witness, Ms. Stang?
Yes, just one. Miss Grant, you've reported that Austin does have releases signed for DHS to speak with providers, but that a new release would need to be signed for Austin's new probation officer. Is that still the case?
Yeah, I tried to send it and I haven't heard back from with the old one that was already sent. I haven't heard back. He had mentioned he needed to sign releases also with his new probation provider, but I can send a new release on our end to the jail and have them sign it or stop in and go down there. That's not a problem. It's just when I had wrote the court report, I hadn't had a chance to do that yet.
Okay, thank you. I actually have one more question. So you also reported that he is still having contact with Miss Double, obviously against his no contact order. However, I believe at the last hearing, you stated that you intended to contact his probation officer to see if that could be modified to allow contact regarding the children. Am I remembering that correctly?
I don't remember.
Okay, well, I guess then, is that something that you think would be appropriate? Since we did hear testimony from Ms. Double that they were contacting regarding the children, is that something that you think would be appropriate for them to be able to do?
If that's something that his probation officer is allowing, the reason no contact is the charge is related to a physical altercation between the two of them. So while I do think he has a right to know about his kiddos, I do the best I can to inform him, but I know that he has more constant contact with Faith regarding his kiddos. So it would really be his probation officer's call if he or she, I believe it's a he now, believes it's appropriate.
Okay, I have nothing further. Thank you.
Okay, Mr. McFarland?
3 questions. Would you believe that the parents who are here in the courtroom today, personally, that their assessment about how their cases are going would reflect how you view their cases progressing?
Yes.
Are you asking for a 90-day review?
Yes.
Is there a distinct possibility that if they progress as they are now, that there could be a request to close the case in 90 days?
Yes.
Nothing further.
All right, Ms. Dumont?
One second. Ms. Grant, have you spoken with Ms. Double with regards to the placement of JJ and Aurora?
are in place.
With regards to them possibly being placed with her.
They are placed with her. I guess I don't understand why.
I believe she means closing the case out and her getting.
Like a permanency
jurisdiction.
planning.
Yes.
Yes, we've discussed that as well.
Okay.
Yeah.
Can you advise what you've discussed with her with regards to that?
Sure, so we've talked about possibly, as long as things are going well in the case, that a permanency planning hearing would possibly be moving forward, that, that recommendation would come. In the case he'd be closed with all four being placed with her, the concern would be the loophole of Austin and how that would proceed moving forward, given his noncompliance in the case service plan, placing them with her, rather it is a custody, through their custody order where he doesn't have time, or if it comes down to possible looking at his rights.
Are you willing to speak on behalf of JJ and Aurora, having a permanency planning hearing sooner than the children shared with Mr. Doobie, seeing as there's not necessarily risk of harm?
I guess.
So do you believe that the 90-day review period is still necessary to get to that point, or what are your thoughts on that?
I guess it would depend if the court wants to look at it as 2 and 2 or as one giant.
Okay, but your recommendation with JJ and Aurora would be to.
Yes, I think they're doing very well with.
Okay, and there's no risk of harm at this point with regards to that.
They're working pretty cooperative with me. I don't think there's a risk of harm for me regarding right now removing or anything, if that's what you're asking. They're doing really well. There's a couple of things with JJ we just have to finish up, but he's doing really great. They're doing great.
Okay, and is there anything else you'd like to see from Ms. Double at this point?
We're just gonna keep trucking along, working on her individual, making sure the transition to family therapy and everything goes well, and yeah.
Thank you.
Okay, Ms. Hines, any questions?
Ms. Grant, I think in this case history, we have a court order for the custody of, trying to think, one custody is, it's not sufficient with Mr. Doobie's case to release custody and because he has joint physical custody, correct?
Correct.
How many hours, can you estimate how many hours you put into looking for him, for this family?
I know the family put in a lot of hours. I know that the department made a lot of phone calls trying to track him down. We knocked on a couple of doors. We went to some of the hotels, following up right behind the grandparents, looking for him. I would say it's quite a bit. I don't know if I could give you a full estimate of what that is.
All right. Thank you. I have nothing further.
Any redirect?
No, Your Honor.
Any recross?
Oh, thank you.
No, thank you.
All right, thank you for your testimony. May I return to your seat? Anyone else you'd like us to hear from? Ms. Thomas?
No, Your Honor.
Okay, Ms. Stang?
I have no witnesses or evidence. Thank you.
Mr. McFarland?
Thank you.
Ms. Dumont?
No, Your Honor.
Ms. Heiss?
No witnesses, thank you.
Comments in closing, Ms. Thomas?
Thank you, Your Honor. We are asking for a 90-day if the court deems that a permanency planning hearing is appropriate. I didn't double check to see what today's hearing was noticed for. But I think that Ms. Grant testified very accurately regarding the concerns and the risk of harm to the children if we were to close jurisdiction right now. One, obviously, is the custody matter with Mr. Doobie. But then two, both the psychological evaluations for Mr. Patterson and Ms. Double indicate, well, for Mr. Patterson, sort of just going through the motions to get things done. And whether there's a sincere engagement and going to be continued benefit from services. The report indicates that we should review the report with caution, given that lack of engagement, so to speak. And it was related to Ms. Double, again, that there's some significant treatment that needs to be put in place before we're able to comfortably get out with to ask the court to release that jurisdiction. Because we do want the parents to make better, have better decision-making, have better judgment, and to be able to safely have their children in their care and custody. So with that, Your Honor, I am asking the court for another 90-day review for all of the children. I think that Mr. Doobie is also in a position where perhaps he can maintain his sobriety longer term and engage in and benefit from some of those substance abuse services that would permit him to safely parent his children. And with that, I think that parenting time for Mr. Doobie be suspended pending our next review hearing, given the CTAC recommendations. I think that there needs to be a demonstrated period of sobriety and compliance with treatment in order to know that it's going to be maintained and that there won't be this inconsistent parenting time with the children, which would pose a risk of harm to their emotional well-being. Thank you.
Ms. Stang?
We would just request another 90-day review period as well to allow Mr. Doobie to finish out his sentence and then hopefully get into that facility after and continue to work on himself and the issues that obviously brought him into this case. But other than that, nothing. Thank you.
Mr. McFarland?
I'm pleased that the agency believes that there may be a request to close the case at the next review, provided both parents who are here in court continue on the same path, and they have their plates full and they're doing that. So kudos to them.
Ms. Dumont, any comments?
Your Honor, Ms. Devil wants the court to take into consideration the ability to have a permanency planning hearing with the 2 minor children that she has with Mr. Patterson. She believes by the time that would be heard, everything that she needs to have done will be completed. She's been compliant throughout this entire process, has completed in-home therapy and has continued counseling with Chris Quinlan. And what she would like to see is to be able to have those kids back without any jurisdiction from the department.
Ms. Heiss?
Your Honor, I think we're trying to build on the progress and to motivate the family to continue to comply. The key difference in this case, you know, we've been open only 6 months, but yeah, about 6 months almost. But the cooperation from the parents and the partnership between the family and the caseworker, I think is something we should build on. It's given us a glimpse inside this family. We aren't hoping for this to be something that closes and changes something in the family. I would hope that the family feels that they are going to continue the services. So whether the case is open or closed, but I understand the impulse to want the true interest, genuine interest in wanting the case closed. But this is something that'll sustain for a long time. And I think everybody's being hopeful and encouraging because the cooperation from the parents has made all the difference. They have a lot going on. They have a lot of strengths and we finally saw it. We finally saw into what Miss Devil does with all her parenting and Mr. Patterson. He really is active with the kids. So I will be looking forward also to closing the case. But you know, this family, I know there's two different dads, but they really operate as a whole. They go everywhere together. I don't understand how it all happens, but it does. And I think that to keep all the kids' cases open and maybe close all of them in 90 days would benefit everyone. The agency was minimizing the amount of time they put into finding Mr. Doobie. It was really stressful for a minute, making sure that his kids had their dad and that nothing bad had happened to him. So I don't know what'll happen with his case in the future, but I think that we should at this time suspend his visits for the benefit of the kids, even though we're so grateful that he's half healthy and where he can't hurt himself at this point. And moving forward, we'll have to address that in the future. Thank you.
Thank you. The parents and parties were given notice for purposes of today's review hearing. It was not scheduled as a permanency planning hearing. The children are subject to the court's jurisdiction on an in-home jurisdiction order. That means that they're still with their parents. And so we have a little more time to look at permanency options.
because they have effectively begun their services and jurisdiction with reunification, which is great. I think the reasons that the court is going to continue jurisdiction are really very well said by the comments in the IHT review. They're going to be focusing in the next 2 months on the goals established for treatment with the family and any new needs that may arise. Collaboration with DHS, CMH, the school, and the Boys and Girls Club needs to continue. Additions and alterations that need to take place include making sure that Jeffrey and Faith, the parents, incorporate the rules of fair fighting into their daily lives, helping JJ get along with his siblings, helping JJ give words to his feelings so he can express his needs, and working with Faith, Jeffrey, and JJ to help decrease his defiance. He's got some case management needs. Needs to continue to have his ADHD symptoms managed. So there's a lot of concerns about this particular child here, as well as coordination with other service providers within the community. And a lot of that is what brought us here in the first place. These are not your average kids. They've got some needs here, and we need the parents to be able to demonstrate that they're able to continue to meet those needs. That's further demonstrated by the comprehensive trauma assessment. The one for JJ is really long. There's a lot of reading materials for the parents in this one as well. And unfortunately, I'm getting the impression, even as I sit here, that both of these parents are just trying to get through this and do what needs to be done in order to get the court out of their lives. I don't want to be in your life, and I don't think anybody else does either. But what we want is for you to make sure that your kids get what they need and are in a safe environment where they're not further traumatized. I don't want them on my juvenile delinquency docket, for example. I don't want them looking at me from a Zoom room where Mr. Doobie is coming from. So that's why jurisdiction is going to stay open, so that you can demonstrate that you've made significant and meaningful changes in your lives and in the lives of your children. I can see you, Ms. Double. I can see you rolling your eyes, and I don't appreciate the fact that you are utilizing quite a huge amount of community resources and being flippant about it. So please.
I've done everything that they've asked me to do, literally.
Okay, that's not going to help you get out from underneath the courts and supervision, because that's not what I see from here. I see some positive changes, and that's encouraging. But I also see you reappearing here again, and that's what we're trying to avoid. So I look forward to the further developments in the next report period, and we'll have our next review on January 6th in the afternoon. As it relates to the request to suspend Mr. Doobie's parenting time, I think that's going to happen de facto as because of the amount of incarceration time that he's looking at through the county and their lack of resources to support parenting time. By the time we get back for our next review hearing, hopefully he will be engaged in his services, but I don't think that there's a reason that I would need to suspend that parenting time, because if he does get into those services and he's able to safely visit with his children, I would hope we would know. I will say we'll make his visitation subject to the assessment of the professionals, many of which are already involved clearly in the lives of the children. So we'll look forward to reviewing jurisdiction, safety measures around Mr. Doobie and his children, as well as the rest of the services, and we'll have our next review on January 6th at 2:30 p.m. Unless there's any questions, that's all for me. I'll have this order ready for you if you.
She expects my client to support her boyfriend, and their new child. She demands money. She demands gas in her car. She demands groceries. She demands diapers. And in fact, he believes that her boyfriend is working out of the marital home using the internet he's paying for. This person that she claimed in her responsive declaration was only a friend, and whom now she is 5 months pregnant by.
I don't receive any support through the state for my other child that lives in the home, who's 10 from a previous relationship, and I don't receive any kind of support for my significant other, who I am pregnant with right now.
That's sad. That's all.
Okay. Sir, is there
Being
anything
greedy.
else you'd like to say?
Besides, that's just a very greedy lady. No, ma'am.
This is our motion, and we are asking that for a number of items. We are asking that the court adopt our parenting plan, although we would like to modify that request with regard to the residential schedule. The parties since August have been doing a 50-50 week on, week off schedule, exchanging on Sundays at 5 p.m. And that seems to be working, and the children seem to be doing well under that schedule. So my client is asking that the court adopt that schedule as part of the parenting plan versus what the local rule schedule was that we put in there initially.
Ms. Lowe, are you in agreement with that change to the visitation schedule? Are you objecting to the proposal made?
Yes, Your Honor, I agree. That's the schedule that we've been maintaining since we agreed upon separation. And it seems to be the healthiest for the children and working out the best. So I agree with the petitioner's amendment to not go with their original parenting plan, but follow with the week on, week off that we've been doing since separation.
Okay. So, and I'm just going to make sure, and again, I know I'm kind of pinch hitting here, so I want to make sure right now we're still on motions for temporary orders, correct?
Yes, this is the first hearing on this case, Your Honor.
Oh, okay.
So we are also asking that my client wants to return to the family home, and I can get into that argument in a minute. We addressed in the motion our request regarding temporary use and possession of the vehicles and property in their current possession, payment of bills. I think that was it, and child support. She in her responsive pleadings requested spousal support, although she did not make a specific request as to an amount. Your Honor, as to the marital home, my client did not agree to moving out despite mom's assertions that he did. The text messages do not reflect that he was in agreement with this option, and in fact, he never agreed to any of it. She demanded he moved out. She barked orders. She told him exactly how it was going to be, and that's what he was stuck with, or at least he felt that he was stuck with. He has a separate property interest in the home from an inheritance that was constituted the down payment. And Your Honor, the fact is, it's my client who can afford the home. She can't afford to stay in the home on her own. She's not working, and that is by choice. And she has since moved her boyfriend in. This person that she claimed in her responsive declaration was only a friend, and whom now she is 5 months pregnant by. So her representation to the court that this individual was just a support friend and just a good friend, no, it wasn't. Which validates my client's accounting of the facts in this case. The situation mom is currently in is of her own doing because of her choices. That does not relieve her of the responsibility now to support herself and to equally support her children. She expects my client to support her boyfriend, and their new child. And so where is her boyfriend's obligation? That's what we have to ask. Why should my client be paying for a house for him to live in rent free? He's not paying rent. And my client is not only the out spouse, but the expectations that she places on him in the text messages are untenable and unfair. She demands money. She demands gas in her car. She demands groceries. She demands diapers. He doesn't mind those things, but he is also paying for her housing. He's paying the utilities. And in fact, he believes that her boyfriend is working out of the marital home using the internet he's paying for. So my client is continuing to pay for the internet and the utilities to make sure that they're paid, and so his credit doesn't get affected, and to make sure his children are safe. But he is seriously being taken advantage of here. That being said, there is absolutely no reason she cannot be working and as the court is aware, we just agreed to a 50-50 residential schedule. So that means that there's no reason she can't be working on her off weeks from the children. I'd like to point out for the court that she did not file a proposed parenting plan. She did not file a financial declaration. We have no idea what her expenses are, what her income is, if she has any. She needs to get a job. If her boyfriend isn't working, he needs to be. If he isn't working, then he needs to. If he is working, then he needs to pay rent. thereby reducing my client's obligation. He can choose to pay rent to my client, or he can find his own place. My client is paying for everything right now and has been since this whole thing occurred, where she just picked up and left with no notice for a month and 3 weeks, and then just expects him to be out of the house, expects it to be in perfect shape, perfect condition upon her return. My client wanted me to address the flea situation and the messiness of the house. The house is not as messy as she tries to represent. And here this guy is trying to take care of these kids and take care of kittens that she initially brought in. She decided to foster a bunch of flea-ridden kittens, and she brought them in the house. The flea issue started because of her. And then she tried to blame it on him, and now she's trying to use this declaration in this court process to say that it's him, it's his fault, it's his neglect, which is not the case. She also made some serious allegations about sexual assault, and then talked to my client subsequently, wherein she informed him that, well, the last time they were together, she just didn't want to. Never once did she say no. Never once did she ask him to stop. She never yelled, she never screamed, she never cried, she never called the police, she never sought a restraining order. Even now, in response to our motion, she's not even seeking any kind of protection order or restraining order against my client. She has no fear. You can't consent to something and then turn around and claim it to be an assault just because it wasn't something you wanted at the time. If you didn't want it at the time, you need to speak up. You need to fight back. She didn't. So she can't come now to the court and say that my client is an abuser and that he sexually assaulted her. To mention the fact that it was not in the middle of a fight. It did not occur out of rage or extreme emotions. It just occurred. They're a married couple. As to requests for her spousal support, she makes no specific requests. She provides no financial documents. We have no idea what the status is of her boyfriend. And she is simply claiming that because they were married and during the marriage, she got to be the stay-at-home mom, she should continue to live that life of luxury just after it was her decision to end the marriage, and not have to support herself or equally support the children. So we are asking that our motion be granted, Your Honor.
Right. Ms. Lowe, I have also received your response. I did not receive a proposed parenting plan from you, but I have received your response to the petitioner's proposed parenting plan. What would you like the court to know?
Well, Your Honor, there's many discrepancies in the petitioner's responses. I would just like the court to know that we had a mutual agreement when I wanted to get divorced that he would move out of the house. There was abuse in the relationship. That's why I left the home, marital home, during the time so that he could move out and it was safe. So when I returned, I have text messages showing that he knew I was at the airport. I was on my way home. He was preparing one of the vehicles for me. And originally he had said I could live in the marital home for a year. And then after I got back, everything changed. I am also 2 months pregnant, not 5 months pregnant. In regards to the sexual assault, I did cry. I did say no. I don't feel like it's necessarily appropriate for court, especially with me with no counsel, but I can't afford counsel at this time. I've done everything in my ability so far of filing TANF and filing for child support. I have thrown out many suggestions to the petitioner, such as splitting the mortgage on the marital home, or him not paying the mortgage at all, and me just continuing to raise the children in the marital home. I've been a stay-at-home mom since the birth of both of our children. So for those reasons, that's why I asked to stay, and that was our agreement. And he was moved out when I came back. So,
And
I'm sorry, Your Honor.
And there's another adult living in the house with you at this time?
There is. I don't receive any support through the state for my other child that lives in the home who's 10 from a previous marriage. relationship, and I don't receive any kind of support for my significant other, who I am pregnant with right now.
And is your significant other who's living in the marital house with you paying any of the expenses for the home?
No, Your Honor, but I have offered to start paying expenses in the home. I've never asked the petitioner to pay the mortgage. It was his conclusion that he was going to keep doing it. He said he didn't want the power to go out on the children. But my only request was to stay in the marital home and raise my children. I'm very flexible on everything else, but because this is a first hearing, we haven't gotten that far, and I can't afford counsel at this time. So I'm just kind of
And then
what I'm able to.
the period of time that you left Washington was about a month and a half, is that right?
Yes, Your Honor.
And the children stayed in the home with Mr. Lowe?
Yes, Your Honor.
So what I'm going to do, going through the petitioner's proposed temporary parenting plan, give you my ruling, and then Ms. Petrie, if you would be so kind as to make any changes per my order. I'll open it up for questions too. Jump in if anyone has questions as I go through this. So number one, in general, I'll adopt the petitioner's proposed plan with some changes. After review of the record, while I do think there is some evidence of probably more like 3B problems on mother's part, I am going to reserve for now on 3A and B limiting factors. We'll reserve those for the final order. Decision making at this time, for school, educational, healthcare will be joint. I will adopt dispute resolution and custodian section 6 and 7 as written. The parenting time schedule, I will adopt with the oral agreement that the parties have made here on the record today. That will include numbers 9 and 10 for summer schedule and holiday schedule. I don't see it directly in here, but I am going to order that Mr. Lowe remain in the marital home at this time. Do not believe it's appropriate for this court to order that Mr. Lowe pay expenses of this home while a new significant other is in the home. I also don't believe, without further investigation, that it's appropriate that the children at this time be expected to reside with a significant other that the court knows nothing about. So Mr. Lowe is to return to the home. Ms. Lowe is to vacate. Mr. Lowe will be responsible for payment of the, and I believe you had that listed in your original motion, all of the expenses related to the home. Yes, which includes the mortgage, utilities, insurance, property taxes, vehicle. All of that will be the responsibility of petitioner. As I understand it, this is a 5-year marriage. I'm not ordering support at this time. I'm not ordering any sort of alimony or marital payments to Ms. Lowe at this time in a temporary order. I will adopt 11, 12, 13, 14 as proposed by petitioner. I'm going over to the temporary family law order that petitioner proposed. So I will adopt in its entirety then the temporary family law order, which does require that the petitioner or allow the petitioner to return to the home and stay in the family home. Respondent must move out of the family home within 30 days of today's date.
Your Honor, will the court address child support today?
I was just going to turn to you and ask the state if, based on my rulings on the temporary orders, if there were any changes to the state's proposals for child support.
There's not. The kids are receiving TANF benefits, and that I know that is a little more complicated because the statute prohibits a residential credit when the children are receiving TANF benefits. Our proposed worksheets were filed November 13th. We used the father's actual income based on his September 29th wage stub, which he filed with the court. The mother has no employment security history, so we imputed her at minimum wage 32 hours per week. I do note that that results in a transfer payment of $1,787 a month from father to essentially to the state of Washington, so long as mom remains on TANF. I do recognize, given your ruling, that may seem somewhat unequitable, but I'm not aware of an exception under the law, at least not in regards to a residential credit.
I do believe a residential credit would be appropriate, considering that they are going to be doing 50-50. And it is for 2 children. I also would request that she be imputed at 40 hours a week. There's absolutely no reason she can't work full time. My client certainly doesn't. He gets by.
And just briefly in reply, Your Honor, the statute, which I don't have in front of me right now, specifically says that a residential credit cannot be granted when a parent is receiving TANF. TANF is evidence that there's insufficient funds in the household to support the children. And then in terms of the mother's income, we followed the imputation statute, which indicates when there's no employment history and a parent is receiving TANF benefits, they're to be imputed at minimum wage 32 hours per week.
Here's what I'm going to do on this, because I don't have, I'm just looking through my papers diligently. Sometimes things get attached to the back of them.
We did not send over a proposed order. I was unsure where primary parent would land.
Understood. Let's do this because let's set this case to December 5 for presentation of the orders I've already ruled on, unless they get signed ahead of time. But it sounds like maybe if Ms. Petrie is arguing that there should be a residential credit, obviously the state's arguing the statute doesn't allow that. We'll set this on for a hearing as to child support on December 5th at 1 o'clock, along with presentation, if that has not already been signed.
Okay.
And then certainly, Ms. Petrie, if you want to file briefing with the court, I'll give Judge Bassett a heads up that issue's coming. But if you want to file any short briefing, feel free to do so. Any questions or clarifications on the temporary orders?
Yes, Your Honor. I would just ask that since the court is granting his petition to have me move within 30 days, given my circumstances of him leaving the home willingly and my pregnancy and having to relocate my other kids, including the ones I share with him, that at this time, I be given more than 30 days to find new residents. I know the petitioner had told me in person that he would extend it till January if it went this way, but I don't know what their feelings are on the matter.
What I'm going to do right now, and one of the reasons I'm making this ruling is I do think it's wholly inappropriate that for this court to have Mr. Lowe paying for household expenses when another adult is living in that marital house. So I am going to keep the 30 days right now. But if Ms. Petrie wants to, if her client wants to work with Ms. Lowe on an extension of that, we can certainly add that to the order. I have no issue with the parties going beyond 30 days. I wouldn't agree to anything less than 30 days. I do think that 30 days to move out is sufficient. But again, if Mr. Lowe wants to agree to longer, feel free to put that in the order. I have no problem signing that.
Okay. Thank you, Your Honor.
Thank you all. If there's no other questions, you all are free to log out.
Like, I just want to know, like, I would love to be able to know where my kid goes to school, so I could know where she goes to school. I have no idea where she goes to school, and she's my biological child. Like, how am I supposed to even figure that information out? And I feel like there are people probably on death row who have at least got to see their kid in the last 8 months or something,
It was witnessed by Benjamin. Okay, so you're here to testify today?
I am.
Okay, so you didn't witness it, you just assume that I kicked your vehicle?
It was witnessed by Benjamin.
Rachel Gold versus Kyle Schmidt. It is Monday, September 30th, 2024 at 12:09 p.m.
Court will note the appearance of Ms. McNiff on behalf of the petitioner in this matter and the defendant representing himself. Is that correct, sir? You're going to be representing yourself?
Yes.
Okay. Ms. McNiff, do you wish to make an opening statement in this matter or proceed to proofs?
We'll proceed to proofs, Your Honor.
Okay, sir, you can make an opening statement or you can reserve on the opening statement or waive your opening statement. What do you wish to do?
Well, I'll reserve it.
Okay, thank you. Ms. McNiff, call your first witness.
Ms. Galt.
Okay, Ms. Galt, we have you raise your right hand, be sworn in, and then we'll proceed.
Do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
I do.
Okay, go ahead, Ms. McNiff.
Thank you, Your Honor. Ms. Galt, you filed a petition for a personal protection order against Mr. Schmidt?
I did.
And can you tell me what happened on August 9th between you and Mr. Schmidt?
August 9th, there was an incident that took place that Kyle was hitting my vehicle, yelling at me, trying to ask to speak to Ben, which I told.
On August 9th, or did that involve a message on Our Family Wizard?
Oh, I'm sorry. That was the wrong incident. I apologize. Yes, there was a message sent to me by Kyle Schmidt on Our Family Wizard about saying he needed to know the full names of everyone parked in my driveway. And he also needed to know who was driving the white vehicle in my car.
And why did that concern you?
It made me known that he is watching my house. And because there is a white vehicle that is in my driveway that is a family member's, but hadn't been there for at least a week prior to that. So
do you know where Mr. Schmidt lives?
In Galesburg.
And do you have any reason, was there any reason for him to be at your home?
No.
And is your home located on a major thoroughfare?
It's located on a crossroad, yeah, a road that is used for traffic.
And when was the last time, if any, that Mr. Schmidt was at your home for a sanctioned reason?
It's been at least 5 years.
And so why did that message concern you?
He has no reason to be at my home or by my house.
Okay. Does he pick up the children at your house?
No.
Have you ever wanted him to pick up the children at your house?
No.
Okay. And you have 2 children together?
I do.
Okay. And was there an incident that occurred on August 22nd?
Yes.
And what was that incident?
That incident was one where Ben was refusing to go to parenting time.
Excuse me 1 second, Ms. McNiff, just to follow along, I've got an incident that occurred on September 5th, August 29th, and August 9th. I didn't have anything in the petition for the 22nd, and am I missing that?
I'll withdraw that question then, since it's not in the petition.
Okay.
Was there an incident that occurred on August 29th?
There was.
And can you tell me about that incident?
That incident was one where we were at a custody exchange and Ben was refusing to go. I calmly told Kyle that Ben was refusing to go and not wanting to speak to him. Kyle then proceeded to hit my windows of my car and continued to escalate and raise his voice. During this time, I was inching backwards to try to leave. And he continued to stay by my car. I inched backwards again, 1 to 2 inches. And he proceeded to start yelling that I hit him, even though I did not. And we made a statement to the police. They did an investigation and I did not hit Kyle. So that was falsely.
What windows did he hit?
He was hitting my windows.
And where was your child located?
During this time, he was afraid. He was hiding in the back hatch of my car. He came forward to the front of the car and he was cowering down between the seats because he was afraid.
When Mr. Schmidt was hitting your window, was he saying anything?
He was continuing to say that he needed to speak to Ben, to which I told him that Ben did not want to speak to him.
Did you roll your window down or was it up?
I did roll my window down, so it was clearly heard.
And how far was your window down?
Maybe 2 to 3 inches, because he had reached in my vehicle prior to this. So I was not allowing my window to be rolled down more than that to put myself into a dangerous situation.
And how hard was he hitting the window?
Enough that it could audibly be heard in the car by my son, and it was hard enough that it was not lightly hitting my window. It was hard enough that it felt aggressive.
So it wasn't knocking?
No, it felt more aggressive than that.
Okay. And was there anything else with regard to that particular date that happened?
I was extremely fearful because I didn't know, with him hitting my window, what was going to happen next, and I was afraid.
And you said you made a report to the police. When did you make the report to the police with regard to that incident?
We drove directly down to the police station.
Okay. And you also indicated that there was an incident on September 5th?
There was.
And that was this year as well?
That was.
And what happened on the 5th?
On the 5th, I again tried to de-escalate, calmly say that Ben did not want to speak to him and was refusing to go to the visit. Again, Kyle continued to hit my window, aggressively. You could tell he was visibly mad, and I was trying to leave due to this. My son was again fearful. I was fearful. And once I rolled up my window and he would not let me leave and was trapping me where I couldn't move my vehicle again.
How did he trap you so that you couldn't leave?
He was standing within inches of my car.
In front of it or in back of it?
Right beside me at my driver's side door.
Okay. And what resolved that you were able to leave?
I got on the phone with the police because I felt like there was no way that I could get out of there safely. When I got on the phone with the police, he charged back to my mother's vehicle. I was on the phone with them and I could not see clearly what he was doing, but I later found out that he was telling my mom that he was going to go to her house.
Well, and let's not say anything.
In regards to me, though, he was still not allowing me to leave and entrapping me in my vehicle.
So when he went back to your mom's car, that allowed you to leave?
I was still on the phone with the police, yes, and assessing the situation.
Okay. And there's been an order entered by Judge Kirkham that prohibits Mr. Schmidt from being within 20 feet of your car. Is that accurate?
That is accurate.
And has Mr. Schmidt maintained that distance?
No, he has not.
And will the police enforce that?
I was told by the police that that was not enforceable under a family court order, and the only way that it would be enforceable was if it was in a restraining order.
So what kinds of restrictions are you asking the court to put into place in a personal protection order?
Everything that I requested in my original petition, and I would also like to request that all exchanges be at the police station, as well as it be maintaining 20 feet away from my vehicle at all times.
You currently have an order that requires all exchanges at the police station, correct?
Yes.
So are you asking that there be a restriction in the PPO that Mr. Schmidt must maintain a 20-foot distance from you?
At all times during the custody exchange, that would be accurate.
I have no further questions.
Okay. Mr. Schmidt, do you have any question of Ms. Gall?
Yes, on you said on August 5th, there wasn't an incident in your report. It says August 5th. It's September 5th. Also on the 29th, the 5th, and the 22nd, I have video footage of the incidents. It does not, it appears that I do not.
Your Honor, I don't
Sir,
believe
sir, sir, this
anymore.
is your time. This is your time to ask a question, not to testify.
Okay. So on August 9th, when I approached your vehicle, you say I was pounding on your windows. In the video, it says that it shows that I'm not pounding. How was I pounding on your windows? I was tapping on them.
I didn't state pounding. I stated that you felt like you were aggressively hitting
How do
my
you know I
window.
was aggressively hitting your window?
It didn't feel
By
like
just
this.
your assumption?
This is how I felt.
Okay. All right. So on let's see. On August 29th, you says I entrapped you. How would I entrap you if I'm standing next to your vehicle trying to do a custody exchange to speak to my kid?
I was backing up, inching backwards.
So I was standing behind your vehicle or beside of it? That's not entrapping then.
I wasn't. I was.
I'm sorry, what's that?
Yeah.
I'm objecting on.
It's your chance to ask questions, not to, again, editorialize or anything of that nature. So you'll have a chance to testify.
Okay, so I was standing next to your vehicle and I entrapped you then, you were saying?
Yes, I was inches away from my car and could not safely back up. I was inching backwards and was not able to move away from. I was not able to back up.
So I would have to be behind your vehicle to entrap you, correct?
No, I couldn't safely move backwards from my vehicle because you were standing so close.
Interesting. So, because on November 5th, you hit me with your mirror, I have it on a video. Did you remember recalling saying I hit your vehicle and you said I'm backing up after I stated I hit you? If in the video you would say I didn't hit you if you didn't hit me, you just said I'm backing up.
I didn't hit you. It was investigated by police.
Do you recall a video ever seeing at the prosecutor's office?
It was investigated by police and I did not hit
Okay, and
you.
the police indicated that you didn't intend to hit me, they stated, correct?
Your Honor, it's both hearsay and not a question.
Sustained. You can't say what somebody else said, sir. Only what the parties, either the petitioner or yourself said, but not other third parties.
Okay. So you stated on the 29th I kicked your vehicle. Do you have a footprint that's on your vehicle?
It was witnessed by Benjamin.
Okay, so you're here to testify today?
I am.
Okay, so you didn't witness it, you just assume that I kicked your vehicle?
It was witnessed by Benjamin.
Okay, well, he's not here today. Let's see.
To clarify, ma'am, so you didn't witness that.
I had my eye on my peripheral vision and he was right there. But
Okay,
because
that's not what I asked. I asked, did you witness it? Okay, thank you.
No, sir.
Okay, then you also stated on another date, I believe on the, let's see here, just going over my notes. On September 5th, you said I entrapped you. How did I entrap you in your vehicle when I was standing next to it?
Again, you were inches away from my vehicle, not making it safe for me to back up safely, which is why I called the police.
Entrapment would be standing behind your vehicle, right? So that means it would be blocking you with a car, a physical person.
To be able to turn my wheel and safely back up, I was unable to safely back up. And because you were inches from my car, I was entrapped in the parking space.
No, that's not the definition of entrapment. On August 29th,
sustained.
On August 29th, you had bumped your vehicle into my wrist. I have it on video, correct? I was videotaping on the 29th.
I'm unaware if you were or not.
I was holding my phone in your vision because I remember you seeing me, correct?
I saw your phone, but I wasn't aware of if you were videoing.
So when we see the video, will it show that I kicked your car in the video then? Will it show that I entrapped you on the 29th?
There was multiple questions. What was the question?
In the video on the 29th, will it show that I entrapped you?
Yes.
Will it show that I kicked your vehicle? Because you clearly
I
said a
haven't,
second ago that you didn't see me, so would it
I
show it in the
haven't,
video?
I haven't seen the video, so I'm
The
unaware.
prosecuting office has the video. You haven't reviewed it?
No.
Okay. Then you speak about August 9th that I had drove by your house. So you physically seen me drive by your house?
Due to you stating that there's a vehicle that is parked in my driveway, that would lead me to believe that you
What
have
road do you
driven
live
by
on?
my house.
What road do you live on? Beckley Avenue, correct?
Correct?
And that's a pretty busy road. There's lots of stores on that road, right?
Correct?
And from Galesburg to Battle Creek, that is a main route to get there, other than the highway when there's construction, correct?
Correct.
Okay, so you didn't visibly see me drive by your house then, correct?
Due to you stating you needed the full names of everyone who has been in my parking lot.
Ma'am, that was not the question.
Oh, I'm sorry. I apologize. I have not visibly seen. No.
Okay, so you haven't seen me. So on the week of August 5th through the 9th, are you aware of numerous marks on Benjamin's legs and arms?
Objection, that has nothing to do with the
Yes,
allegations.
yes,
Yeah.
it does. It has to do with the messages that I sent her asking who's at her house watching Benjamin.
Well, it's not for purposes of this proceeding. I mean, you can testify that why you did that, but it's not germane to this.
Okay. So are you aware that my mother has a doctor in Battle Creek that she goes to, correct? You saw her at the hospital one time when you were working?
I'm aware that
Okay, so you did see her before in Battle Creek?
yes.
So is it possible for anybody else to drive by your house and state to me that there was a white car in your house, correct?
I don't know, possibly.
Well, it's a yes or no question.
Well, she
Okay.
answered it. She said possibly.
Okay. So I think that's all. I have nothing further.
Okay, Ms. McNiff, any redirect?
Briefly, on the date when you indicated that you believe that Mr. Schmidt kicked your car, did you hear anything that would have indicated that he had come into contact with your car?
No, I did not.
And Mr. Schmidt indicated that he has been videoing you. Is that accurate?
That is, he's been holding his phone up. I believe it could be video or photo. I'm not quite sure of either which one.
And have you had any discussion about him taking the videos of you?
Yes, I've asked him to stop.
And has he stopped?
No, he does not stop.
And how does that make you feel when he's taking videos of you?
Fearful, afraid, and unsure of what it could escalate to.
On video?
I have
Sir, no comments.
I have no
Sorry.
further questions. No.
Okay, you have a right to recross, sir. Only as it relates to items that Ms. McNiff went into on her redirect.
So, Miss Galt, when we were at the Shell station in Battle Creek, are you aware that's a public place?
I'm aware.
Are you aware that you can videotape in a public place?
I am aware, but I asked you kindly to please stop.
Okay,
And
that's not the question. Are you aware it's a public place and you can video?
I'm aware.
Okay, so if you were fearful and there's a video being taken, wouldn't that make you feel safer because it's on a video that somebody could actually review if they requested? If you felt unsafe, that would make you feel safer, correct?
No, it did not make me feel safer.
But it's on video. It's a recording, right? That would show the incidents that happened. There's 4 of them that I have. Is that correct? That you've asked me once to stop videoing, correct?
I was unsure if the situation would escalate, and it did make me feel fearful.
But how can you predict the future of what's going to happen? How are you? Can you read minds?
Objection, Your Honor, argumentative.
Sustained. Just address the facts, sir.
Nothing further. Thank you.
Okay, thank you. Ms. McNiff, any other witnesses?
I have no further witnesses.
Okay. Mr. Schmidt, do you wish to testify?
Yes.
Okay, raise your right hand, sir. We'll have you sworn in and then we'll proceed.
Do you solemnly swear or affirm the testimony you're about to give shall be the whole truth and nothing but the truth?
Yes, ma'am.
Okay, what would you like to tell us, sir?
On August 22nd, August 29th, and August 5th, I did video record the exchanges due to her not releasing my son to me. And I do have her on video. I did not entrap her. I did not hit her vehicle as she claims. I did not kick it. I tapped on the window. I knocked on it and asked to speak to Benjamin. Once she refused, I would say, well, it's not your choice. Can I speak to Benjamin? And she would want to roll up her windows and ignore me. I'm there for an exchange. I don't feel it's correct what she's doing. I believe that's all.
Okay, thank you.
You're welcome.
Ms. McNiff, any cross?
Mr. Schmidt, have you spoken with Ms. Galt's mother at any on September 5th, 2024?
It states on a PPO it has to be Rachel Galt we're speaking of.
Ms. McNiff, I think he's making a relevancy argument. How is that relevant?
In the petition, Ms. Galt alleges that Mr. Schmidt threatened to go to her mother's house on multiple occasions and threatened to stalk her mother's house.
I believe her mother can file a personal protection order if this did occur.
Yeah, I'm only going to pertain to these parties. Okay, hold on. I'm only going to address issues concerning these parties, not third parties.
Okay. I have no questions for Mr. Schmidt.
Okay. Any additional witnesses, Mr. Schmidt?
I'd like to show you the videos.
Okay. Well, you're going to have to share screen and do that.
Okay. Let's see here.
Well, sir, let me say, I don't think I need that at this point. So
Okay.
We'll go ahead. Any closing argument, Ms. McNiff?
Your Honor, we are simply asking that this court enter a PPO that would restrict Mr. Schmidt from any stalking behaviors as are listed in item 5E of the petition, that he be prohibited from going to Ms. Galt's home, and that he be prohibited from interfering with or using any efforts to remove the children or any personal property from her premises. At this point, she is, and that of course he'd be prohibited from assaulting, attacking, beating, molesting, or wounding her. These parties have a long storied history of domestic violence and conflict, and these attempts at parenting time exchanges have escalated to the point where she is fearful, and Mr. Schmidt has been engaging in behavior that would cause her to be fearful for her safety, her physical safety. And we would simply ask that the court prohibit him from being able to continue to intimidate her.
Okay, thank you. Mr. Schmidt, any closing argument?
Yes. As far as she requesting stalking, I have never attempted or would want to stalk Mrs. Galt. I have never showed up at her residence in 5 years, she had stated. As far as removal of the children, I've only picked them up at exchanges, and that's it.
Okay, thank you.
You're welcome.
Well, in this case, the court has to look at the statute which is involved, and that's MCL 600.2950, And the court can enjoin and restrain certain conduct if the court determines there's reasonable cause to believe that an individual has committed or may commit the acts listed under MCL 600.2950 parens 1A through K. In this matter, first, it's been alleged she's fearful of him entering the premises. However, she did acknowledge in her testimony that he had not been to the premises for about 5 years, obviously, so there's no fear of entering upon the premises. She says she's fearful, first, she's fearful of the videotaping, but the point that Mr. Schmidt makes is appropriate, that if, again, if he's videoing it, then she should feel safer, not feel unsafe or fearful because of the fact that it's all videoed and all records. So the court doesn't, again, believe that that's appropriate under sub K, where she might, in fact, cause reasonable apprehension of violence because somebody is videoing her. She may not like it, but that doesn't mean that there's going to be any, again, violence as a result of that. In fact, the court would believe, as did Mr. Schmidt, that it'd be less likely to be any particular violence. She claims he hit the window. He claimed I was tapping on the window to get her attention. The court has, through the ex parte order the court entered, has taken care of that by keeping him 20 feet from the car when the exchanges occur in this particular case. The court notes that the other objection, nope, you guys are done. It's my turn now, Mr. Schmidt.
Okay.
The court does note that she states she hasn't seen him, she's never seen him go by the house, so she can't claim that he was engaged in stalking behavior. He did raise the point, maybe somebody related to him that they saw a vehicle at her house. That doesn't denote that he, again, was engaged in any behavior which would be stalking under the applicable statute. The court in this matter does believe that court's taking care of the issues that would be germane in this matter about being next to her vehicle, and believes that that is taking care of the matter. I don't believe that it's appropriate nor necessary to enter a PPO. I will deny the petition for entry of PPO at this time. So you're free to go today and have a good day. And
okay. All right. So explain this to me, Ms. Curtis. I was a little unsure about exactly what the relationship is between the two of you and Ms. Yell. It looks like you are all tenants in the same building. Is that right?
No, we live in a trailer park and there's no relationship other than she's just my neighbor that lives on the side of me, and
Okay.
and that's it.
Okay. So, and you say that she yells at night. Is she yelling at you or at Mr. Palaia? What's the story there?
Yeah, in a passive aggressive type of way. She has come over to my house several different occasions, like screaming and yelling up at my door and accusing me and my boyfriend of weird things that are completely like unexpected. And she says things like we're trying to control her internet and her Roku and just random weird things like that. And she said she makes up stories about us trying to get us kicked out of here to my landlord and to the police, and it's just gotten out of control, and I've let it go for quite a long time now, and it's getting to the point where like I'm starting to feel kind of threatened, pretty threatened. And
Okay. How often does she come over?
well, she hasn't come over for, I don't know, what, a few months maybe? Yeah. A few months probably at this point in time, but she does other things like calls the police on us and makes up stories and stuff. So, and goes and makes up stories about us to the landlord, and it's all, so like when I first moved in, she thought that I was sleeping with her boyfriend. Her boyfriend lives on the other side of me, lives on one side, her boyfriend lives on the other side.
Right.
For some reason, I don't know why, she thought that I was sleeping with her boyfriend, and which is not even close to the truth. And so that's kind of all what started it. Ever since then, she's had something out for me, and I don't know why. And it's just been like a whole, I don't know. She's came over and apologized actually, and like left notes and like gift bags of used clothes and used makeup and stuff, and apologizing and saying that she's bipolar and she's so sorry that she acted that way and whatever, and it won't happen again. And then I'm like, okay, you know, whatever. And then it'll happen, then she'll deal with something else and it'll happen again. And it's ridiculous. I just want her to leave me alone.
How long has this been going on?
Since I've lived here for what, over a year? Almost 2 years, yeah.
Okay.
And it just seems to be getting worse. Like I don't even pay any attention to her at all. I don't have anything to do with her. I don't even think about her. And then she'll do something and say something crazy about me. And I just really want her to leave me alone.
Okay, now you indicated in your petition that she threatens you. What does she threaten?
Yeah, she's threatened. She'll like, she'll be outside in the middle of the night, like screaming and yelling at how she's gonna kick my ass and whatever, and just random crazy threats.
And you know it's directed at you.
Yeah.
How? Is she using her name, your name, or what is she
Yeah.
saying?
Yeah. For sure. Me and my boyfriend.
Okay. So she's directing it to the two of you,
Mm-hmm.
not just yelling at the moon.
No, like she's definitely is at us.
And you said that she threatened to use black magic. What do you mean by that?
So I found a phone outside in my backyard one time, and because she cuts through my yard to go to her boyfriend's, and so I found a phone out there and I didn't know whose it was, and so I looked at it to try to find out whose it was, and I went into the messages and I started reading some of the messages, and it was her talking to one of her friends about us and how she thinks that I'm sleeping with her boyfriend and she's gonna do some black magic spells on me, and I don't remember the details of it, but it was kind of scary, you know. And then we gave her phone back.
Okay.
I did take screenshots of all those.
And Mr. Palaio, do you have anything you want to add?
That's about it. I mean, just it's crazy. We don't have nothing to do with her. She's really.
Okay, but so if I understand correctly, it's been a couple months since she has come over to your property. Is that right?
Yeah, but she's done other things. Like she called, like a week ago, she called the police on us and had the police come out, and we weren't even home. I don't even know what she told them, but I saw on my cameras that the police were at my door, and I did some research and I found out that she had called them and some kind of type of disturbance, and we were at work. We weren't even there. So she made up some, I don't know what she said to them, but they came out and to my house, and I'm like, she does stuff like that, even though she doesn't directly come to me anymore. She does stuff like that, or she'll go to my landlord and tell him that I'm trying to control her Roku, and stealing her internet and just weird random stuff like that.
Okay, thank you.
Mm-hmm.
Ms. Yell?
Basically, I've never threatened or intimidated or made any verbal threats towards Rose. I've maybe had 3 conversations with Rose, and those conversations were over 2 years ago. And I apologized to Rose and resolved that issue. I feel that Rose is retaliating against me to purposely make me look out to be the perpetrator. And I'm not the one who's cussing her out or calling her names all night long. That this verbal abuse from Rose has been going on for the last 6 to 9 months. I'm not the one who's monitoring Rose or Gustavo's behavior. I have never bothered them or observed or monitored them or stalked Rose, nor have I ever verbally threatened or bullied or called Rose any names. I've been kept all hours of the night, being called a fucking bitch. I hate you. I'm going to kill you. I've had both Rose and Gustavo state to go kill myself, and I should have shot you already. I've had my Wi-Fi hacked into, and I had many disruptions, too many to count. Rose has kept me up for 4 or 5 days, making these threats over and over all night long. I couldn't call the police in fear of Rose's threats of retaliation. I did notify the manager of the park, and he advised me to file an anti-harassment order, and I told him I would think about it. Rose claims that I keep her up all night, but I sleep 12 hours a night, and I turn my TV down at 10 o'clock. And in the past, I've asked Rose to please respect my privacy, and her response was, "You think I'm up and jealous of you, bitch." Because of Rose's threats Rose has made towards me, I now feel for my own safety, and I've had to go through so much stress, strain, and mental duress. I'm exhausted, confused, and afflicted. I'm unable to cope with my daily life, and because of the situation, I recently signed up for counseling, and I've had 2 appointments. I missed 2. I've had to change my door locks 2 times, and I've changed my internet provider 2 times. I recently ordered home security to keep myself safe in this situation. It has cost me my finances, my health, and my safety. It's been a financial burden on me, and Rose has caused me strife and abuse for the last year. I've done nothing wrong but keep to myself. I don't get involved in neighborhood drama nor any of the neighbors, and I would like the behavior to stop. I just want peace of mind, and I'd like to be left alone and be able to live in solitude, where I can have some kind of peaceful situation come to this resolve. I've had to put up some windows on my windows because Rose and Gustavo were looking in while they were pretending to water plants. I've had to keep my windows and doors closed because of the constant eavesdropping. I feel like I have no privacy in my home. And basically, I know that Rose makes sure that when she leaves that has Gustavo watch me and monitor me while I'm there, so I can't call 911 because she's accusing me that I'm calling 911 all the time on her for the last year. And basically, I've had to go to many medical appointments, and I've had panic attacks because of the situation. I live alone, and I don't have any friends or family to go through, so I live in fear and in trepidation. And basically, I felt like I've been followed on a number of occasions, but I've suffered so much mental distress because of this, and I've had breakdowns, and I just want the behavior to stop. That it's not me that's doing this, that it's Rose that's the one who's the one that's harassing me. Right. And I provided with you some statements from some family and friends, from Roger Yowell, and I provided a statement from Raina Pearson, Rita Nice, Miles Toll, and my neighbor Ramona Bear. And then I provided some documentations of my journals. And thank you, Your Honor.
And Ms. Curtis, do you have anything else you want to add?
There's not one bit of truth to any single thing that she said. Not one single bit of truth. I've never ever even purposely talked to this lady in my life. Not once have I talked to her or had any. I don't understand why she even thinks this stuff about us, other than her thinking I was sleeping with her boyfriend. That's when it all started. And her boyfriend had told us on numerous occasions how she's crazy, and every single one
She's off her medication or something like that.
And all of our neighbors will say how she's crazy and bipolar or whatever mental illness she's got that is paranoid about people. And she thinks that we would want, for some reason, to stalk her or even know what she's doing. I don't care about any of that. Like, she's of no importance to me. I don't even think about her. I never have. So all these are just delusions, and I would appreciate it if she got some help, because it's kind of affecting my life, and I really don't want anything to do with this drama. I don't have problems with any of my neighbors. So
Thank you.
it's honestly kind of sad if she really believes that kind of stuff. It's kind of concerning and sad.
All right, listening to the two of you, Ms. Curtis indicates that there had been a period of time in which Ms. Yao was yelling at her, taking offense under the belief that Ms. Curtis had relationships with Ms. Yao's boyfriend. That apparently, the direct contact from Ms. Yao to Ms. Curtis apparently stopped a few months back. There's a concern by Ms. Curtis and Mr. Palaio that Ms. Yao reports falsities to the landlord in the trailer park, and also has been calling the police and making false allegations, and leading to at least one stop by the police at Ms. Curtis's and Mr. Palaio's residence when they weren't present. On the other hand, Ms. Yao says, in fact, it's the opposite, that she's being harassed by Ms. Curtis, and then Mr. Palaio watches her, and she feels under duress from the pressure they're putting on her, and has asked for a realignment of the parties. There was a temporary order issued in this case. I'm going to first indicate to the parties that this court, I don't have any authority to tell somebody not to call the police. I don't have any authority to tell them to not talk to the landlord. I don't have any authority to tell them to tell the truth. If Ms. Curtis or Ms. Yao is going to go to the landlord and say things that aren't true about Ms. Curtis and Mr. Palaio, we don't have the authority under this process to tell her not to do that. And we don't have any authority to tell her not to call law enforcement. It's up to law enforcement. It's up to the landlord to make the decisions they want to make and decide whether they want to listen to what Ms. Yao is telling them or not. So I'm going to find that Ms. Yao is not directly contacting Ms. Curtis and Mr. Palaio at this point in time. I will not enter the protection order. And the one temporary order will cease as of today. I will, however, make a record that Ms. Curtis and Mr. Palaio, Ms. Yao have made very clear that they do not want any contact from you. So they have the right to come back and refile this order if you contact them in the future. You are to, there's no order here, but you are well advised not to have contact with them, since they have made very clear that they don't want to hear from you at all. And on the other hand, for Ms. Curtis and Mr. Palaio, Ms. Yao has said that she doesn't want to hear from the two of you, and she has the right to make that request and has made it. So Ms. Yao has the right to file a petition if she believes that you contact her over her objection to have contact. You both have asked for the very same thing, that is, leave me alone. So hopefully the two of you can live up to that. But as I've said, the court will not limit what somebody can say about somebody else, and doesn't prohibit people from calling law enforcement or speaking to their landlord. That's something the court will not address. All right, I've signed a denial order. Thank you both.
Azara Staffield.
Your interpretation. In this case.
Your Honor, I'm not quite sure. Last time we appeared in the court had advised the parties to all reserve all the documents that had been served because of some last pleadings the defendant filed. I haven't received any additional pleadings from them. We did file an answer to those pleadings. I do notice that there, I pulled the docket today, and there is, as of today, some reference to a dismissal with prejudice. And I'm not quite sure what that would mean in this.
Well, the problem is, and I don't. Okay. You've not received any documents that you attempted.
Nothing
So
since
the-
the original delivery that I placed on the record.
At the last hearing, I struck all of the documents that had been filed by the defendant in this case, because she had changed the caption. They were to be refiled and served.
They were not.
Was that done, ma'am?
Yes,
Was that done?
Your Honor, first of all, we have not been.
Ma'am, I asked a yes or no question.
Yes, Your Honor, we served the plaintiff with the joinder we filed and in federal court, we did. The plaintiff did not send us any pleadings. I have not received any complaint. I have not received, he has not followed the rule 5.108 of 7-day notice that he has to give me. He is in violation of professional responsibility, rule 7 and 8. We have not received any complaint, or he cannot produce proof of service to us, Your Honor. But we can provide proof of service that he was served by sheriff for federal claim.
Let's try this again. The last time that you were here, I told you that you had improperly changed the caption on the pleadings. I struck those pleadings, told you that you needed to refile them with the correct caption and serve them on opposing counsel.
Yes,
my sole question to you is,
okay.
Did you do that?
Yes, Your Honor.
Did we get a new filing? Yeah, because if she filed them and served them, they would be in my court file. And it's odd, I don't see new filings in my court file. And I don't see, and counsel's indicating he didn't get it, but she's telling me she didn't.
So according to JIS, today an answer and motion to dismiss was filed.
That was
not by me, Your Honor.
Yes, okay, I see that, but that was not the original.
I have not seen that.
Service on here, I don't. I still have Carl Staffield on this case, and I don't know why.
Because he's a resident too.
Then he needs to properly join the case. I don't. You did it again. The caption you just changed.
May I speak, Your Honor?
Yeah, go ahead. We did the same thing we did the last time.
May I show this to you?
No.
This
you did the same thing.
No. This notice to appear is only addressed by the plaintiff for my daughter only, who is out of town, and we received it in the mail yesterday. And it doesn't even have my name on it.
Who filed this dismissal?
We did. I did.
You're not the plaintiff.
I'm a counterplaint.
Then how do you give me a notice of dismissal regarding this case
That was
and not sign it?
I'm sorry.
You filed a dismissal of the case under the section notice of dismissal by plaintiff. You are not the plaintiff.
I am a counterplaintiff, Your Honor.
I am not accepting any of these pleadings until you get the caption right. I'm not accepting these sort of random documents coming in as a dismissal, a notice of dismissal. The only thing that you would be entitled to dismiss would be to the extent you believe you have a counterclaim. That's the only thing you're going to dismiss. You can't dismiss his claim.
Yes, Your Honor. May I say one more thing, please?
Go ahead.
My grandmama died, and we are flying out of US next week to attend the funeral. If you want to.
I'm not going to allow you to continue to delay these matters through some improper procedures that you're employing. I'm not going to let that happen. My condolences on your loss, but I am not going to just continue to lay this matter out to have you continue to do the same thing.
What am I doing wrong, Your Honor?
I have already told you what you're doing wrong. If you don't think you're doing anything wrong, then maybe you need to get an attorney.
Okay.
That's licensed to practice
Okay.
to do this.
Okay. Could we have next hearing after April 1st, please?
I'm not going out that far.
Your Honor, this is the third appearance in this case.
Oh, I know.
You gave her 2 weeks after the last appearance.
To get everything right.
And you admonished her to get an attorney at that point.
I did.
Yes.
Striking those pleadings. Don't file anything else that's improper and not properly filed with this court. I'm just going to be that direct.
Good.
Matter will adjourn to March 21st, 2020.
If I may, Your Honor, briefly, just briefly. This is not a rent case, Your Honor. This is
I know.
Termination of tenancy. The lease has been up for 60 days. She's staying in there. There was an escrow order that was filed. To our knowledge, she hasn't paid the rent. To our knowledge, she didn't pay the jury fee. To our knowledge, all these things have happened, and my client is being prejudiced by the moment here. There's damage occurring to the premises. There was construction and landscaping that was violative of the city ordinances and the HOA standards. We have a witness here today to testify that the property is being damaged as we speak, and we need.
What way?
There's significant runoff and sediment runoff. The backfill was backfilled 4 feet to 5 feet to more over the base of the trees in the backyard, and that's been that way for some time. The fact of the matter is she's had more than, I'm defer to the court, of course, but she's had more than an opportunity. She's filed this federal suit. She's doing everything possible to delay our occupancy. And I just don't think it's equitable or right. It's up, of course, your decision, Judge.
Oh, I know.
She knows well what she's doing to buy time here. And she served all these pleadings. She claims she doesn't have an attorney. I read the pleadings. They were drafted by somebody other than her, it appears. She hasn't followed one rule. She hasn't served me once correctly. The person that's named in incorrect caption isn't even a tenant on the lease. I don't know where they came from here, but they're non-party. My clients had to pay me to come in here and deal with all this sort of thing. And I'm just, they've joined us in a federal case that names almost verbatim the same cause of action that's named in this very counterclaim that the court struck and apparently dismissed with prejudice. All I would ask the court is that I possibly could get if she wants to appeal this, and I would pretty much bet she's going to when the time comes. Let's get that process started, if at all the court would go along with us. Let's get a judgment for possession entered. We can give them a little extra time if they want to put in the appeal period and get us our judgment. And then she can do what she's gonna do anyway when she gets her day in court, according to her. She's been here 3 times. I've traveled from Oakland County.
I'm sorry to hear that.
3 different, yeah, me too. 3 different times to be here, Judge. None of what she files makes any sense. And it's just not right on my client's behalf to let my client continue to suffer while they occupy the premises without any consideration. She's going to appeal this if we win, and we probably will. The point being, let her appeal. Let's get that process started if that's what she's going to do. Thank you, Judge, for listening. Yes.
Okay, good.
I want to answer.
Go ahead.
Your client, sir.
No, you will address me.
Okay, I apologize. His client, Your Honor, is a loan shark who bought our property in a redemption period and signed an agreement to let us buy this house back from him. We are ready to go ahead buy this house back, but while his client was owning this place in last 9 months, the Barton Village put a lien on the property. Now we cannot get a mortgage because they have a lien on the property. And by him in this court trying to put me down because I'm representing myself is also another violation of you.
You need to talk to me.
Yes.
Go ahead.
Okay. Your Honor, we have served everything. This gentleman cannot provide one proof of service to this court. He gives us papers last minute. We received this in the mail yesterday. He did not serve us properly.
That was the escrow order only.
Okay, I'm sorry. Please don't interrupt me. Thank you very much. I didn't interrupt you when you speak. Extend me the same courtesy, okay? This loan shark and his attorney are trying to.
Are you almost done?
Yes, to take us out of our home. And they put a lien on that house. So now we can't even get a loan to purchase the mortgage to purchase the property because it has a loan. Now he's asking us for the possession. We paid the rent, but the rental agreement is over. We want to buy the house. The lien doesn't let us buy the house, Your Honor.
I would ask for one brief moment to respond to that. If the court wishes.
Why are we doing this? Okay, so here's what happened. I told you what I was going to do.
Enough said.
You wanted to talk, then you wanted to respond. And now you want to go back and you guys want to spend all day going back and forth. Tell you what, we can put you over there on the side. I can handle all these other people's cases so they don't have to sit through this. I'm required to. And you guys can just go back and forth, and then I'm going to do what I was going to do 5 minutes ago.
Thank you, Judge.
Okay.
Hearing nothing else, March 21st, 2025, 2 p.m. You get the pleadings right or get an attorney in here. Thank you.
Thank you, Judge.
Ma'am, you're not gonna yell when you're in here. You're not gonna whisper under your voice. I don't operate that way. Understood? No. Understood. I heard you all the way up here. Have a great weekend.
Thank you, Judge.
Can you do me a favor? Can you go out there and just make sure they don't like? I don't want to call anymore. I'm done. I'm so done. Yeah, here, you take it. All right, let's try this one. I can't let you have it if you're not gonna be unbiased. All right. Danetta Masick versus Lula Williams.
Late fees, bounce checks, and all of this. And I'm looking at it like $1,400 worth of late fees and bounce check fees? What kind of check did I bounce?
Now, I'm sure we've all had those situations where we had somebody speaking to us or at us in a lot of cases, and you just can't help but think, my God, would this person just shut up? Pretty much the exact same face as the judge and the lawyer in this situation. In fact, I'm sure a lot of you probably watched me before and thought, God, would he ever just shut up? But I've never experienced it quite like this before. I'm going to go a bit old school Irish demon here, and I want you guys to give me some of your best, but don't be too mean, but some of your best nicknames in the comment section down below. Best one gets pinned.
All right, the court will call the matter of, recall the matter of YPF 16 LLC versus Annette Dukes and Ray Dukes, case number 25C0952.
Good afternoon, Your Honor. David Fanter on behalf of the plaintiff.
Please unmute, state your names to the Dukes. You're unmuted, Ms. Duke. Please state your name. Thank you. Ray Dukes, please unmute your device and state your name.
Raquana Dukes.
All right, thank you. All right, we're here today in this non-payment of rent case. My understanding is that the parties are unable to reach an agreement. Is that correct? Can't make out what you're saying, ma'am. Your device is not.
That right there was probably the biggest mistake that the judge made in this case, was informing her that we couldn't pretty much hear her at all. Because once that was resolved, by God, she didn't stop.
She says she guesses correct because she's not understanding why she owed that much. And he wasn't really trying to explain either.
Well, that's not true, Ms. Dukes. Annette called me this morning. I called her back and said that it was because she bounced 2 checks and didn't fully replace them. And she said, okay, I said, how much time do you need? She said 3 weeks. I prepared a judgment and sent it over to her, and then we're having a conversation in the breakout room, and she decided that, in fact, that wasn't okay. So please don't tell me that I didn't try to explain to her, because I explained it to her a couple hours ago.
Sorry, but he did try to explain it to me. I'm still not understanding it because I did bounce 2 checks. Well, I didn't bounce them. The computer bounced them back to me. Their computer system. They switched over and didn't let me know. And when it bounced it back to me, I took all of the money and mailed it back to their new payment system, which is a totally different payment method, because they wouldn't let me use the payment system no more because they say I bounced too many checks. But I did not know they switched over. I sent them all the money that they had sent me back. And that was supposed to be covering that much rent. I sent it all back to them. The $900 and something, they came back to me. I sent it back to them.
Well, the amount of
I thought that covered it. What is this other amount is what I was talking about. And then you said that it was late fees, bounce checks, and all of this. And I'm looking at it like $1,400 worth of late fees and bounce check fees? What kind of check did I bounce?
Ms. Dukes, please stop yelling.
Ms. Dukes.
Oh, I'm sorry, I'm not yelling because he couldn't hear me, and I thought it was my speaker on my phone. I am so sorry. I'm in a.
Your Honor, now she's making stuff up because I never said it was late fees or bounce check fees. She
Yes,
bounced,
you did.
Hold on.
Wait, didn't she just tell us that she wasn't going to shout, that she wasn't shouting? I knew when he said, no, she's just making stuff up, that she would immediately shout. Sorry, I'll rewind that so you can see it again.
now she's making stuff up because I never said it was late fees or bounce check fees. She
Yes,
bounced,
you did.
Hold on.
Right, everyone, please stop.
He
She
did.
bounced,
Now you yelling. Now you yelling. Stop.
she bounced checks in the amounts of 600 and 570. So she bounced 2 checks totaling 1170.
Looks like she got so angry there that she literally fell off that bridge.
She bounced checks in the amounts of, the only payments we've received from her was money orders totaling 933, and there's another month due. So, A, she didn't replace the amount that she bounced, and B, there's a full another month due. And so it's not just NSF fees or bounce or late fees. It's the fact that she replaced only about 80% of what she bounced. And number 2, that bouncing was in early February, and the only payments we've received since then is March 3rd. You know, if you add up the fact that she was $200 short plus March's rent, that's how we come up with the $1,464 that we say is owed.
So on March 3rd, what amount did you receive, Mr. Fantera? Is that the 900 and something?
We received 430. We received 2 money orders, one for 433 and one for 500.
So that's the 900 and something that you mentioned there.
So we never received the payment. So again, the amount of check that we were bouncing was 600 and 570, which is 1170. So if you say that there's 1170, if you say that there's 1170 minus 933, she still owes 237 on the bounce checks, and then owes March's rent, which would be 886, which is, so that's 1123. And then you add the court costs in, which is 188, that's 1311. So that's, you know, so that would only leave $153, which probably is NSF and late fees. So, I mean, you can't count that 933 2 different ways. You can't say it's March's rent, because if it's March's rent, then she hasn't replaced any of the NSF or any of the bounce checks. So that's the explanation for what she owes.
So ma'am, you are entitled to have a hearing if you disagree with the amount that's owed. Are you requesting a hearing on this?
Ma'am, I am so totally lost because I don't understand all of this, because all the money that I was supposed to pay, I started trying to pay it to them, and I don't know what happened.
Miss Dukes, so he's explaining what they have and what they have received, and they've only received $933 after the $1,170 checks were.
That's the YPF LLC.
I'm sorry, we
I said that's the YPF LLC people that got the $900-something, because who got the other amounts of money that I first started sending them in February?
Nobody got it. Nobody got it. Nobody.
Have they checked with
y'all checked with Red Shield Rentals, because Red Shield Rentals will not return my calls. I have not heard from them.
Your Honor, I want to be clear. YPF 16 has always been the owner. It changed management from Red Shield to.
Well, MTH LLC, where I wrote the check money.
Miss Dukes, seriously, I'm gonna need you to stop interrupting people. Mr. Fantera, you may proceed.
YPF 16 has always been the owner. It changed management from Red Shield to MTH. I have the ledgers for both Red Shield and MTH, and other than the 433 and the 500, we've received no money since the beginning of February.
All right, Ms. Dukes, what were you gonna say?
At the beginning of February, I did send Red Shield Rentals $600 money order. I mean, a $600 payment in their portal, the tenant portal that they used to have to pay the rent. It didn't come back. It wasn't the one that came back. When I tried to pay March's rent, that's when my money order started coming back.
Right.
Because they wanted me to pay it to another portal that was called MTH LLC.
All right, so it sounds
Okay.
like we need to have a hearing in this matter because we're not going to agree today. So what we're going to do is schedule this for a hearing. Is everybody available at 10:30 on this Friday?
Yes.
Ms. Annette Dukes?
I guess I'll clear time,
All right.
even
And
if I ain't out there.
Ms. Raekwon Dukes?
I mean, at work, but I can try.
All right.
I assume you mean by Zoom, Your Honor?
It is by Zoom, correct. If folks don't show up, then it defaults. So at that time, you can present whatever proofs you have as to what you believe you paid so that we can have a hearing on this. In the meantime, Mr. Fantera, please make sure you send them copies of the ledgers if you have their email addresses.
But I want to be clear so that I can check one more thing. Ms. Dukes, you say you've made payments into the Red Shield portal, correct?
Yes, sir.
How much?
I think it was a $600 payment.
All right, Your Honor, I will have my client check both portals to see if they have any payments so that everything's accurate when I come back on Friday.
I can't remember which one came back. Was it the 570 payments, 570 something payment, or the $600 payment? One of them came back.
There were two payments that came back, one for 600, one for 570.
Okay, and then it was for 600. It was the first one was 600.
All right.
All right, we'll see you all here on March the 21st, 2025 a.m. via Zoom. If you have any proofs of anything that was paid, please submit that to the court. You can call the clerks and they'll give you the email address to submit it, okay?
Your Honor, is it the same Zoom number?
It is the same Zoom number,
All right.
okay?
Okay.
I'll see you all on Friday at 10:30 a.m.
Okay.
Thank you.
Well, that one was definitely a really tricky one. It's like, what happened to the days of like, you be here at this day and that's it? Like, I'll see if I can make it work. I mean, let's face it, what are you doing? But anyway, folks, thank you so much for joining me. I really do hope you enjoyed the video. Don't forget to give me some of those lovely nicknames down below, but please keep them nice. Don't be mean. It's not how we do things around here. Anyway, folks, we'll catch you in the next one. We got an awesome one coming as well after this one, so definitely make sure and subscribe and hit the notification bell, and we'll catch you at... What are you looking at? We'll catch you then. Sláinte.
Everybody, welcome back to the Irish Demon here, back with another video. Just a quick apology about the sound quality. My microphone had a bit of an incident, so I'm just waiting on a replacement one, so it might not sound as clear. Pro tip for you, if you're going to be asking a judge for something, probably a good idea not to slam her on social media and to other judges. This judge does not take that kind of nonsense.
We will go on the record in the matter 24 FO 275, Town of Menon versus John Armstrong. The Town of Menon appears through Chelsea Whitley by video conferencing. She was on her way to court to be here in person, but the weather is now in a terrible state and she had to turn around in luck because she could not get here safely. So she's appearing by video. John Armstrong appears here in person without counsel. We're set today for a court trial. But before we begin, I do have to bring something to everybody's attention. Mr. Armstrong, I believe I need to recuse myself from this case because it's been brought to my attention that there's been numerous postings that you believe that I'm not that I'm biased and I'm not partial, or that I am partial and I'm not impartial. And you don't believe that you're going to get a fair trial and all of these things. And I'm going to tell you that my whole job is to ensure that people can get a fair trial, and that's my job. And also, I also want to let you know that courts don't decide where people live. Courts don't decide where people go after they're done with probation. Judges don't decide that. People don't decide those kinds of things. I don't get to make that choice. And so those are things that I think that people should be more informed of the justice system and know how it really works before they spew things all over, because it's not fair to the people who actually know how the system works. And so I don't care what you say or what you said about me. I really, truly don't. It doesn't hurt my feelings. It's my job. But I want to let you know, and I'll let you in on something that I didn't find out that I had a group home 3 houses down from me until I got a case where there was a shipment, a huge box shipment of THC vapes sent, and I was on that case. But you want to know what? I had to dismiss that case because somebody's constitutional rights were violated. And so as a person, that kind of, I'm like, wow, I just found out I have a group home like 3 houses down from me. And there was a shipment of THC vapes sent to this group home. As a person, I'm like, wow. As a judge, I have to look out for people's rights and their constitutional rights. And that person's constitutional rights were violated. And it is my job, my responsibility, my ethical duty to dismiss that case because that person's rights were violated. And that is exactly what I did. That is exactly
Understandable.
what I do.
This may be a lot different than vapes, though.
Well,
Yeah.
the thing is, I'm not going to get to know because you have already stated on social media, and again, it's been sent to me by multiple sources, that you think that you're not going to get a fair and impartial trial.
Yeah, I sent that letter away when it started. I sent that letter to you.
Well,
As a matter of fact, I sent you a letter 2 years ago that you never replied to or never responded to.
there's such a thing called ex parte communication.
Understandable.
Where judges cannot respond to things by individual people. And there are, in cases, only some people can write letters and do some things. I can't respond to letters that are sent to the court and to be put into a file. I would be able
Understandable,
to respond
yes.
here if we have an actual trial and as a judge. That's where my voice gets to be heard. I
Understandable.
don't get to be heard until that time.
I guess I was sending it out for public awareness. I sent the letter to 3 judges and I got a response from 2 of them.
Well, I don't know.
So here we are. So
I'm going to guess that, well, I don't know. I can actually go and talk to those judges because I'm friends with all of the judges in District 10.
well, I've also brought a witness that he said the state asked for 9 to 12 months and he was out in 3 months. And there were 2 roommates
Here's the thing.
that are
Here's the
pedophiles
thing.
in his house.
Here's the thing that you don't understand about the law. There are higher courts that direct what courts have to do and what I
Understandable.
have to follow.
Yeah. You're not getting all the information.
I know I'm not, and neither are you. And that's what I'm saying.
Yeah, I've got
And
stacks
that's
of
why
it.
I'm saying I'm recusing myself so you can have the fair and
Perfect.
impartial trial.
Thank you
that
very much.
Believe that you want to have.
Thank you.
And so you'll be assigned a new judge. And then you can have the fair, impartial trial that you wish to have. And however it goes is how it's going to go.
Will I be able to request a jury trial?
No,
Because I requested that earlier,
this isn't a jury trial case,
but I requested it initially. I requested a jury trial.
but it's not a jury trial case.
On the letter from the court said that I had an
Talk
option.
to the new judge and you can make your case
Perfect.
with the new judge.
Thank you. Thank you very
And
much.
so that's what's going to happen.
Yes.
But again, it makes it very difficult for the justice system when people don't understand how it works and what happens. I would love for you to come and sit in court, not only my court, in every court. Go sit in Polk County Court, go sit in Washburn County Court, go sit in Barron County Court, and see how courts function and how they work.
As a matter of fact, I was sitting here for Randolph Peckman's sentencing that he didn't show up for.
That wasn't my case.
Yes, it was. You were.
It was John Anderson's case.
He didn't show up.
It was Judge John Anderson's case.
And so there was a warrant out. The warrant got squashed, and then the charges were dropped, and he's back in the house, and the windows are boarded up.
You can go and look at the back. It was Judge John Anderson's case because he took that case. So, know the facts.
Okay, well, thanks for your time.
I issued the warrant, yes, because he didn't show up, but that's what happened after that, because I issued the warrant because he didn't show up.
Yeah, I actually gave you his address in court because you didn't have it. And so I asked Finch the next day if a warrant went out. She said no, she hadn't heard nothing. And then 5 days later, the warrant finally went out. Meanwhile, he was gone across the country. This is.
I issued a warrant. That's all I can do.
Yeah. Well, who squashed it?
First of all, it's not squash. It's called quash.
Oh, okay. Well,
Squash a warrant.
I got a message from.
Again, follow the cases. Come and sit and follow all of the cases, and then you can learn the information. I don't know what's going on here because I don't know anything, because that's what I do.
Yes.
My job is to sit here and to hear about your case and to hear about from town of Menon. I know nothing about what's going on in this case. I know there's a citation. That's what I know.
Thanks for giving me the opportunity. I was able to watch your video the other day, and respectfully, I feel for you guys. What I got out of it is that silence is cancerous and it's deadly. And that's what's been going on for 2 years. Silence. I've been silenced by everyone.
Well, you're going to get your chance to be heard, and
thank you so much.
You're going to have a new judge, and hopefully it's going to take place soon. So Ms. Whitley, I will get the documentation done, and also though, you need to have it in person. Ms. Whitley should be here in person.
Yeah, I understand the situation. Yeah, I was surprised that court continued today because the roads are terrible.
I'm going to tell you, I've been sitting here since
all day.
Yeah, all day, and I don't know what's going on.
It's terrible. Yeah. All right, thank you.
Thank you. Thank you, Ms. Whitley.
Yes, I apologize. Thank you.
Well, there we have it, folks. It seems like he spoke before he thought. Now, we've all been guilty of that, but in this situation, definitely not a good idea. I really hope you enjoyed the video. If you did, make sure to hit that like button, and we'll catch you in the next one. Sláinte.